Present. Original side, Group 8 hearing. Have given notice.
Original side?
Original side matter. Group 8 hearing.
Group 8 hearing.
Group 8 hearing, have given notice.
Matter of which year?
কোন বছরে আছে?
Matter of which year?
Which year? Year জিজ্ঞেস করছেন যে 2024 মানে 24
মানে এটা যাবে
ওটা রেখে দিও, original side list যবে হবে কথা বলে।
Maybe your lordship, my lord, there are I am mentioning 4 appeals, my lord, arising out of 2 orders, similar order passed. My lord, what has happened? I have filed the contempt petition. I am the respondent writ petitioner, but because of pendency of this appeal, my contempt application is kept pending. That's why, my lord.
Who is your other side, Mr.?
My lord, I have given the notice to the state, my lord. Mr. Amritulal Chatterjee is other side. Group 8 matter, my lord. These are applications, my lord.
Application?
My lord, application.
Identical situation, my lord.
Notice you have given?
With notice, my lord.
Well, I'm mentioning for one matter for inclusion in the list.
What?
Inclusion in the list.
No, application?
Yes, my lord.
New application?
New application.
It was not heard earlier.
No, my lord.
Appeal of?
Appeal?
Which year?
2026, my lord.
26?
Yes.
Lordship, I'm playing for inclusion in the list as urgent motion. I am the appellants, and although I hold valid TET certificates and I am otherwise eligible, but I'm not.
Are you mentioning about notice?
No, yes, sir. It was supposed to be listed today, but it is not appearing in the list. And one more.
You mentioned it.
New application.
New application, it has already been appearing. It's supposed to be listed today, but it is not appearing somehow. And a similar.
I'm mentioning upon notice. This is MAT number 1509 of 2015, Your Lordship. Lordship, this was appearing in the monthly list. And Your Lordship, I had mentioned about 4 times earlier, Your Lordship. And on 2 weeks ago, when I had mentioned, Your Lordships were pleased to tell me that you wait for.
Which is the matter?
Lordship, this is the MAT, Your Lordship, against.
Is it in the list?
Yes, Your Lordship.
Which item?
Item number 61.
So it will be taken up. We will call today. Call today.
Very well.
Yes, call the list. তুমি এক কাজ করো, এটাতে একটা ফার্স্ট কল দিয়ে দাও আপ টু 63, তারপরে ডাউন।
First call, বলুন first call.
ফার্স্ট কল বলো।
First call. Item number 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 5, 6.
I am for the respondent mission.
Seven, 28, 29, 30, 31, 32, 33.
Lordship, is this monthly list going on?
Yes, ডেকে যাও।
35, 33, 38, 29, 30, 31, 32, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60,
61, Your Lordship, I'm appearing for this.
62, 63. Item number 1.
Second call.
Well, I'm for the,
Item number one, I'm for the.
I'm state respondents in this matter, my lord.
Yes.
My lord, this honorable court directed the state respondents to file a report in the form of affidavit upon the principal secretary, finance department, director of madrasa education, and the secretary minority affairs department. My lord, I am praying for accommodation some days because of the facts, my lord. The finance department will take a decision few days ago, my lord. Kindly, my lord, kindly see the order dated 21st May. Second page. Serial number 7 and serial number 10.
21st May.
May, ma. Kindly see the page 2, my lord. Serials. Last line, my lord. After the views of the finance
Yeah,
department.
that's the. Yes.
My lord, finance department just few days ago, my lord, they're taking their views, my lord. Views discourse, and I am praying for accommodation sometime so that I can file 3
There
affidavits, my lord.
3 reports were directed to be filed.
My lord,
One by the directorate,
yes, my lord.
one by the principal secretary,
And
and
another.
other by the secretary of
Minor-
minority
Affairs.
affairs.
Well, I shall file one. Give me some time. So,
You are, how long time you
my
require?
lord,
This was
I'm.
21st May.
My lord, because of the facts, my lord, the finance department
You
after.
are appearing for all of them.
Yes, my lord. My lord, after getting the information from the all over West Bengal, collecting the records all over West Bengal, they collected and received the documents, papers. After receiving all the papers from the.
When will you file the
My
reports?
lord, I shall file, my lord, within 2 weeks, my lord. Kindly accommodate, my lord. Adjourn for 2 weeks, my lord.
Mr. Hossein Lanet, advocate.
Yes, madam. That matter, that commission matter contempt,
Yes, my lord.
it was taken up no, on Friday.
Yes, my lord.
We made the returnable date as 20.
Yes, my lord.
But 20, it cannot be taken up. There will be some problem. So we will be keeping it on 20. Here, Dr. Patu, the content matter,
Yes, yes,
Friday, which we fixed, returnable on 20th,
yes,
that date has to be changed.
very well, very well.
So, can you, I have asked my officers to call the persons who are there, because again, if it is listed and dated, that is a clumsy affair.
Very well.
Keep it on 20.
Uh,
2 p.m.
Very well. I will inform the learned advocate general and all the other parties also.
Yes, and if they have any problem, let them come to us at 2 p.m. so that with consent we can fix the date.
Very well, very well.
I'm also there.
I'm also. Mr. Lahiri is also appearing in some of the
Cannot take
matters.
it up on 20th. There will be some problem. On 24th, we will take it up. That is a Tuesday at 2 p.m. The date লিখে রাখো দুটো অন্য কিছু নেই তো?
If the learned advocate general does not have any problem with the date, I will not unnecessarily come back and disturb your lordship.
Very. If you have any problem,
Then only I will just come back.
I will inform the other applicants.
yes, kindly inform. Otherwise, they will be
I am there in other matters.
because we have not uploaded the order. It
Yes,
went
yes.
to signature. The date problem was there. 24th at 2 p.m.
Very well, I will inform.
ওটা একটা নোট করে রেখো, এই যেই অর্ডারটা সার্ভার হয়নি ওটা ফাইল দুটো পাঠিয়ে দিও তাহলে। Dr. Patru, please inform.
Yes, 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 I will.
Yes, next matter.
Matter number 2.
2, 3, 4 affidavits are being affirmed by the Panic Executive on the next week. I'm just
ওরে আমাদের
the matters
file হবে।
together, my lord. 4 is the main matter.
The next monthly list, it will.
File হবে।
No, next month, near the top it will appear. Exchange your
Even this time.
next monthly list. Yes.
কবে থাকবে?
Kindly, my lord,
Exchange your evidence in March monthly list. ওই যেরকম কলমে আছে ওতেই দিয়ে
My lord, may we file our opposition in
file it on that day.
that day?
Yes, next 2, 3, 4 হয়ে গেল। 5.
For 5.
দেখি ফাইলটা দাও।
Monthly list.
I'm praying for SWAT Passover, my lord, in this matter.
Who is the applicant?
We spot the
I'm led by Firdaus Sami, I advocate Firdaus Sami, my lord.
Evidences have been exchanged.
My lord, affidavit, my lord, we are affirming it today, my lord. By course of the day, my lord, I will hand over him, my lord. Kindly, my lord.
File your reply, it will appear next monthly list.
But today, my lord, I will affirm it. The course of the day, my lord, I will hand over. Your lordship can record it, my
You
lord.
are not recording, you give
Mal.
the copy so that he can also file a reply.
Mal.
This item, next monthly list 6.
Matter number 3.
Appellant. Appellant petition.
No.
Litigation response. Appellant is the state.
Who is opposing you, Mr. Badi?
Mr. Abhishek Prasad.
Issue, what is the issue?
The issue is the, my lord, the
Higher scale. Covered by Utpal Kana.
some argument is required that
Then we keep it next monthly list. Yes, next monthly list.
Number 7.
My lord, for the appellant, this is of 2021 appeal, despite several direction.
Is your election, Mr. Badi?
this fourth and fifth and sixth March. From
My lord, despite
Lordship,
there
in
being
item 7,
specific
there was a
direction,
direction to file.
Lord, several directions was passed upon the authorities. This is of 2021 appeal. Despite that, they have chosen not to file the affidavit. Last occasion, it was your lordship's view that if they don't, we will proceed with the matter.
Lordship, the
This is
affidavit is ready.
2021.
We have sought for explanation with regard to one point, my lord.
6 years.
Adjourned, it goes to the next monthly. Why
My lord, kindly.
Kindly adjourn it. Let us come back with the affidavit. One particular point,
There was
I have raised the issue with the client. They have not yet
last chance
managed to
was
give
given
the
on the
answer.
last occasion. My lord, kindly take it up after 7 days.
Very
Previous
well,
to the
I-
was last chance, my lord. Kindly 7 days time may be given. Kindly fixes any day subject to lordship.
issue transfer?
No. This is regarding the appointment of headmaster, some anomalies in the recruitment process itself. in the appointment of the headmasters. Honorable single judge has observed, very interesting. First part of the judgment observes, yes, it should not have been done. But the last portion of the order, it has been.
What written order you want?
No, this is exchange of affidavit. It is final hearing. It is ready for final hearing.
So you file your paperwork, Mr.
Well, reports have been filed.
He will. We can pass a formal order for paper. There is no scope for interim order. We dispense with the. We will dispose of the stay application, and you incorporate. The writ petition was not on evidence.
On reports.
Report in the form of an
Report in the form of affidavit, my lord. Nothing is required to be added.
You don't have. You will not improve upon that.
No, one point which my learned friend is raising, for that I had asked for an instruction because a different instruction was given to me. So I wanted that to be clarified, that whether Mr. Lahiri's contention is correct or our contention, there is some mistake.
26 February record of complete.
No, in between exchange of affidavit, my lord.
Yes, yes.
Cannot possibly further or that we said last.
Yes, that is.
I need only 2 or 3 days. I will
I'll
give it to
request
my
my
learned friend
learned
by
senior-
Friday.
Well, I request my learned senior friend to give me that copy so I can give the reply also.
Copy to the.
Yes, yes.
Come
Yes.
back on কবে বলছো?
26 February. Great.
Deeply obliged.
Grateful.
And 8 কেন নয়?
8 2 p.m. 2 p.m. fixed আছে।
ও আচ্ছা।
তুমি কোথায় লিখেছো?
হ্যাঁ, এই তো।
ও আচ্ছা। হ্যাঁ, বাবা কোথায়? Respond.
I'm the respondent. I am appearing on behalf of respondent. Mr. Bari is appearing on behalf of appellant.
ঠিক আছে। আচ্ছা, Mr. Bari has no track now. Yes, sir. Next monthly list, yes, 10.
Next monthly list, madam.
10, 11 also.
9, 10, 11.
9, 10, 11. Next
Nine.
month list. Yes.
I'm deeply obliged.
Yes. Adjourn due to election.
There are lots of best prices.
Adjourn due to ensuing council election.
Next monthly list.
Yes, item number 12.
May I pray for not today, my lord, led by Mr. Shubhish Arnal, my lord, senior advocate, my lord.
Who is
Please
opposing?
But council is a answering respondent, my lord, Nodia council.
Next monthly list.
I am on behalf of the petition, appellant minor.
Your appellant, come this side. They filed the. Your appellant in Maheshwar Malodas.
My lord, my
And who is
lord. Alia
filed by you?
my lord,
Filed 2 appeals.
my lord.
Against 2 orders.
2 orders, my lord. Earlier occasion, my lord,
What order was passed last occasion?
my lord, paper book submitted before, not my lord. Order is there, my lord, but not submitted.
You have not filed paper books.
My lord, I
Yes, good, good.
You have served upon other side.
my lord,
আমাদের পেপার বুক কোথায় দিয়েছি?
Where is our paper book? You have filed it
my lord.
just now.
Department
Department file করে। হ্যাঁ? So file your paper books next month, please.
Lord, may I just interrupt? I had a talk with the learned advocate general. 24th, 2 p.m. He will be able to. So I will inform everybody.
Otherwise they will come and scold us.
Number 19.
19, I appear on behalf of the personal respond. In spite of repeated direction, they did not.
মানে 20 I appear for the writ petition and respond.
appeal for the Union of India.
It is the Bishwabharati's appeal. আবার টাইম নিবি? পাঁচশোবার?
Sir, my senior is on the way, my lord. Senior is on the way, my lord. I'm paying for a swap
This is the
password.
third time they're asking for password. This is the third.
Let him come.
Singh is on the way, my lord. He'll be here in a
Who is your senior?
Mr. Victor Chatterjee, my lord.
Uh-huh.
Mr. Victor Chatterjee.
Victor, file to the
শুরু করো।
paper books file.
Yes, yes.
Order him to leave at which page? Take your
Page 187.
page. Why two paper? Even the supplement.
Yes, yes, yes.
What is it?
But this is regarding continuation of service of mine in the Vishwabharati, as well as granting the financial benefit in terms of the continuation of service, whether I'll be given the benefit of 65 years benefit, or as a teacher I will retire at the age of 60, because I was appointed as an assistant professor in Vishwabharati. Now I was discharging. Thereafter, after discharging my duty, I have been sent to that school where I am discharging the duty of a teacher. Because in Vishwabharati, there are two sets of, within the university, there is a school. In that school, I was discharging as a teacher. Now, the difficulty is in the writ petition where I own the Honorable Single Bench. Kindly have a look to the order of the Honorable Single Bench once for appreciation of fact. Kindly give me 1 second, please.
187.
187. Yes, sir.
187.
The longish order. Mm-hmm. 187. No.
41.
Just. No. Yes. Starts from 241. 241. তোমার কাছে 241 নেই? Yes, I'm ready.
Paper base is not telling.
হ্যাঁ, এটা তোমার কোনটা দিয়েছে? হ্যাঁ, ঠিকই তো আছে।
241 পেজই নেই আমার।
Why there are, by this order, two writ petitions were disposed of?
Yes. But one is mine. First is mine, Sandip Kumar Bhagat, and second is Kalicharan Hembrab.
But he has not preferred it.
No. But against Sandip Bhagat, they have preferred the appeal, in which I am appearing.
And in respect of Kalicharan,
I don't know, I don't have any information.
Now what theory paper book is not telling. Paper book is not telling.
তোমার সঙ্গে আমার ট্যালি করছে না কেন?
Math 340.
হ্যাঁ,
241,
346. এটাই।
My paper book contains total 228 pages.
this is a more than
Last page is 228.
Same.
paper books were filed by you.
No, by the Vishwabharati. I'm the writ petitioner respondent. Now, the pages are, the page numbers may not tally, but the pages are telling. কি করে হলো এটা?
187 আমার হচ্ছে ট্রায়াল করে ওটা দিতে পারবো ওটা দিয়ে
তোর কাছে পেপার
অর্ডার শিটটা দেখি
আমি পুরো করেছিলাম, নোট করেছি।
How you have written?
Number according to the 60 I have retired.
Now whether you are discharging duties in school?
I was in Patho Bhavan.
Now you are attained the age of 65 also.
But at present, just a second, no, I have not reached 65.
Oh.
I have not reached 65.
Then have you been given the pensionary benefit?
But because of the pendency of the appeal, but there is a stay of this order. So I could not be able to get anything.
Why? Your 65 may not have been given, but 60 has been accepted.
60 has been accepted, but no, the order enhancing my service career, that has been questioned before this court by the division bench, by the
Admitted pension.
very well. Kindly grant that, because I'm starving. Because of the pendency of the case and because of the stay granted by Justice Shane Mallet.
Coordinated bench when the stay order was passed.
I was not there. No, I was not there. Now, Justice Shane has almost completed the hearing. Justice Shane.
So you have to go to Kerala then.
262, kindly have a look. The order of the division bench. The revision of pay. ওইটাই দেবো ওখানে। দাঁড়ান লাগবে না।
ওরাই দিছিল মুখ্যমন্ত্রী বলে আমার নিচে পেলাম আর কিছু না।
এগুলো আমার নোট।
এইটা না, এইটা তো মুখ্যমন্ত্রী, এটা আমার।
So your recovery order was your page 253. Respondents were restrained from effective recoveries. By the in the stay application. Well, sorry.
But SKB is me.
Areas of pay and a new scale.
New scale.
You are getting pension.
I have not received pension because of the pendency of this appeal. This order has been stayed by the Honorable Division Bench.
No, only 2 and 3.
Portion stay.
2% stay.
According to me, I have not received anything.
So then why didn't you tell the court?
I told the court, Justice Sen was on the opinion that the appeal will be taken up for hearing. My Lord, Justice Sen was taking up the hearing matter with the appeal.
Take appropriate steps.
If your Lordship kindly takes up the appeal as a whole, and pass your.
That is a Kamla's issue, na? Your contention are you should get the pension.
Absolutely.
So what is the
under which pay scale I'll get the pension? I was
without prejudice.
Very well. Kindly pass that one line order, so that I can survive. Because I was appointed as an assistant lecturer. Now, I have been discharging my duty in the school. School does not. In the Pathabhavan school. Kindly have a look to the definition of page 21. And 67.
Yes. Where is he?
He's engaged in another matter, my lord.
But kindly have a look to page 67A. How I have been appointed as assistant lecturer in mathematics. 67A type code. Assistant lecturer cannot be given a post in the school. I have been appointed by the registrar in 1989.
Your claim is that you are assistant teacher of a school.
Yes, because Pathabhavan
teacher in a school.
Yes, Pathabhavan is a school which is in the within the framework of the Shantiniketan, Vishwabharati. And the definition of Adhyapak, page 21, paragraph 7. Page 21, kindly have a look, Malay. The definition of Adhyapak, Granthana Vibhag. 67A, with reference to your application dated so, I am directed to inform you that you have been selected for appointment to the post of assistant lecturer, mathematics, in Shiksha Shatra on the following terms and conditions. Last line, if the offer of appointment on the above terms and conditions is accountable to you, please.
Page 21.
No, 67A, my appointment letter. Please. Then, my lord, kindly have a look to page 69A. How the Executive Council, in its resolution, has mentioned, notified my name. Page 69A, type copy. Serial 3, Dr. Sandeep Kumar Bhagat, Assistant Lecturer in Mathematics, Shiksha Shatra. In the service book, page starting from page 71. Same, page 72, Assistant Lecturer. Post. Got it? Page 70. And at page 73 is the salary slip. Kindly see right hand top, designation Assistant Lecturer 2. 73 is the type copy.
Yes.
Then your lordship, kindly have a look to page 75. Option form. I have designated as Adhyapak. Page 82. The website, page 82. In the website of the Vishwabharati Malad, I have been mentioned as Assistant Professor, Department of Shiksha Shatra. Area specialization, PZ Algebra.
What is full form of KVS?
KVS. Kendriya
Vidyalaya.
So we dismiss. Oh, you are there. Yes. So why you are not giving attention as per the admitted scale?
The scale which he is claiming, my lord. The scale which he is claiming, my lord.
kindly comes to page 154A, my lord. That is not entitled to.
Have downgraded him to a particular scale, good, bad, indifferent. Yes. Now the appeal court has restrained you from effectively recovery from. Now he has crossed 60 years. So as per your claim also, he would be entitled to his pension even if it's as per the earlier scale. So why you are not disbursing?
In the admitted scale, he is entitled. In the downgraded scale.
So he will accept it without prejudice instead of waiting in the queue for years.
Yes, right. That can be done, madam, because here in the downgraded scale, he is entitled to pension. In the downgraded scale, he is entitled to pension.
But Mr. Bhattacharya says that no pension.
Nothing. But that, my lord, may I just take the instruction because
No, that instruction won't help. You bring a written communication.
my
Because there was a direction not to effect recovery. That direction crossed towards them, and the other direction was 2 and 3. The other
2 and 3 has been
2 and 3 stayed.
2 and 3, and 3 was
2 and 3 stayed. Only one, my lord, there is no stay in respect of number 1 direction.
question.
$253.
Only recovery part has been stayed.
The trial court restrained them from effective recovery.
Trial court restrained them from recovery.
Right.
And
the second direction was that he would be eligible to the pay received prior to introduction of EBC.
Yes.
And third is the
shall we enter into the receive area?
areas of pay direction was taken.
Now we will consider the assistance order. We review the directions contained in
2 and 3
2 and 3 stayed.
So recovery and areas payment has been stayed. So
2 and 3.
2 and 3.
One already stayed by the travel.
One has?
One, so far as one. Respondents are restrained from everything recoveries from the erroneous remunerations, pay and benefit. That has been stayed by the trial court itself.
Right. So recovery issue is not. So issue is whether he will get the scale which was prior there. So now admittedly, the person has attained the age of 60 years. So there can be no apparent hindrance towards giving him the pensionary benefit.
in the downgraded scale.
Does not possess the prescribed qualification, qualification prescribed by Ministry of Human Resource Development. It is your main contention most probably.
And he was discharging.
And hence he is not entitled to get the KBS scale. It is your main case.
And he was discharging duty
So
in a school.
take us to that page or
But he was discharging.
what is the prescribed qualification?
He was discharging his duty in a school, not in a school and not in a capacity of a assistant or a professor. But his appointment letter says he is appointed as a professor, assistant teacher, but he was actually providing service in the school of the university.
No.
Then we will take it.
No, madam. Kindly, may I take the instruction on the pension part, madam, that he will, if he gets the, what is the difficulty why this pension is not been given? Give me, kindly fix it after 2 days, madam. I shall take the instruction.
If admissible benefits can be given in the meantime, you call him and complete it.
Very well.
And thereafter, if it fails, you will hear out the appeal.
Very well.
During course of the
Mr. Chatterjee, don't keep it there. Find that it is available. Then there has to be certain formalities being complied with. If we require the signatures and everything, service status, you call the petitioner by that time.
Yes, yes, but the petitioner is in Shantiniketan. He resides in Shantiniketan.
Yes, yes.
Great. In both the matters, I am for the state led by landed GP. Madam.
Why two appeals?
Yes, my lord.
Why two appeals, Mr. Andrew?
21 and 22.
two appeals.
Because, my lord,
it practically arose out of the same judgment. Because of this reason, my lord, the writ petitioner claimed, my lord, the enhancement of the age of superannuation.
Where is the writ petitioner?
The petitioner, Mr. Mitra, is there.
It's
I could
appearing
find him.
since long. He's not appearing, my lord.
It's not appearing.
No, since long, my lord, he's not. He was appearing earlier.
In the read code, he appeared.
In writ court, he appeared in the appeal court also, my lord, when the matter was in before court number 8. He was there on some days.
In person.
No, not in person.
Repainted by Jayanto Mitra.
One Mr.
Repainted Jayanto Mitra. The petitioner repainted by Jayanto Mitra.
He has retired.
No. The person concerns have retired long ago.
Oh.
Long ago.
What is the issue in this?
The issue is, my lord, that some, my lord, laboratory instructor and laboratory assistants, my lord, moved the writ petition jointly as far back as in the year 1990.
Claiming?
Yes, my claiming the teaching status, the benefits.
This has been decided by the Supreme Court.
That is different thing altogether, my lord. I'm coming, my lord. Then in 1996, my lord, our honorable court, my lord, was pleased to allow the writ petitioner, directing them to give the teaching status with all consequential benefit under the university statute. Now, my lord, the thing is, then, my lord, a committee was constituted. Committee identified the areas of consequential benefits. Objections were sought for, and, my lord, they accepted that whatever scale will be given, they will accept it. Then, my lord, ultimately, my lord, as teaching status, with the teaching status, I'm emphasizing on this word for some reason, my lord, I'll come later. Then, my lord, a minimum scale of UGC scale was given to them. My lord, in the meantime, during this grant of the scale, because it was everything was with the higher education department, government of West Bengal, because it would be approved by them and all these things. My lord, a contempt application was taken out on the plea that the benefits and the order is not being complied with. The contempt application was ultimately dismissed. Subsequent thereto, one of the writ petitioners, my lord, moved the writ petition, my lord.
Contempt disposed of.
Contempt dismissed, my lord.
Dismissed.
Dismissed.
Holding that there is no violation.
No. There is no deliberate violation as has been observed. I shall refer to that order also, my lord. Subsequently, another, my lord, one of the writ petitioner moved the writ petition before this honorable court. The honorable court, my lord, was pleased to pass certain directions, my lord. It was appealed against. The appeal court held, my lord, that since the minimum scale UGC has been granted to them, and that they are practically not regular teacher within the meaning on the cadre strength, my lord, they are liable to retire, my lord, at the age of 60. But that ended there. Subsequent thereto, my lord, this writ petitioner, on the basis of, my lord, a circular of 2016, my lord, moved the writ petition, where, my lord, it was stated that the all the regular teacher substantive capacity, they will retire at the year 62. In 2017, my lord, another circular was issued enhancing the age of superannuation as 65. Then another writ petition by the same person, my lord, was done. But the learned single judge, my lord, in both the writ petition allowed inter alia holding that they are entitled to retire at the age of 65 years. Initially, my lord, when the petition was moved, my lord, two petitioners are there here. One of them retired, they accepted the all retrial benefits without any demur. Just, my lord, one of them, my lord, made a representation that my service may kindly be extended, which was not done in view of the fact that they are liable to be superannuated at the age of 60 years. This was the factual background, my lord. Then, my lord, the appeal was referred by the university, contending that the teaching status and the regular teachers are not the same within the meaning of the University Act. and as well as the, my lord, the circulars or notifications issued by the government of West Bengal. My lord, that is only thing that those two circulars are required to be interpreted by my lord. This is the position. Now, my lord, may I take, my lord, the initial.
So their teaching status has been declared by a coordinate bench.
Coordinate bench, my lord,
that part, that declaration has attained finality.
Attained finality. Teaching status, there is no dispute,
so
nothing of this sort.
So only whether they will get benefit of 2016 or 2017
yes, my lord, whether
or not,
they can be treated
it is the matter to be considered.
They can be treated to be a regular teacher, my lord, within the cadre strength. Because, my lord, all these posts.
Page 167.
Yes, ma'am.
Both of them as retired. Page 167.
Yes, yes.
Paragraph both
Yes,
retired.
yes, ma'am. The petitioner number 1 retired on December 31st, 2017. And the petitioner number 2 has also retired on January 31st, 2017. They have retired, my lord.
Next paragraph.
Next. In that view of the matter, the writ petitioners are allowed with the direction upon the respondents to notionally treat the petitioner number 2 to be retired on January 31st, 2022 and release all retirement dues, including the pension accordingly. Now, my lord, if the notional benefit is directed to be paid, my lord, treating him to be a regular teacher, then all the, my lord, pay scale and all other things are to be, my lord, restructured. Your lords will appreciate this. Because, my lord, the notional benefit in that event
It has not been said anything.
No. Only
You have been asked to change. Have retired at 65.
Yes.
And you will give notional approval of the said period of service.
Yes. Notional
He
approval.
attains 65.
Meaning thereby, my lord, the increments and all other things has to be given.
No, that has not a notional benefit. That will not be break. We will clarify that. So
But clarify, and not only because of this reason, otherwise there will be difficulty unless and until this is interpreted. Because of this reason, they are
what interpretations are. This becomes academic. The persons have retired. They will be getting notional benefit on the basis of 65. It will be in the facts of the case you will be disbursing. What you are apprehending, that apprehension is that today if the notional benefit is deducted,
yes,
then he would be entitled to all the increment.
Not only that, my lord, there are number of petitioners who are there. All of them may come, my lord.
What is the impediment on the part of the university in complying with this? There is no declaration of any status. See the direction, very innocuous direction.
And my lord, the next paragraph, my lord.
So further to reinstate that question does not arise because the person has already attained 65 years. Question of reinstatement at this stage doesn't appear. In 2 weeks, within 2 weeks you have not done. He has been allowed to retire on 31st December.
Yes, yes.
Then what are you wanting from us? What more information, interpretation you are wanting?
Interpretation, what I was seeking.
You are thinking. Thinking will not do, Mr. Banerjee.
No, I am seeking what I am seeking. I am submitting, my lord. That this
your grievance is that he should not be given. There should be no declaration of such teaching status.
There should be no declaration that he is a regular teacher of the university.
Very good. That the court has also not come into. The court has said that 22 he will retire. You treat him to be in service till 65 years. Subject to what you point out.
And if only, my lord, for my satisfaction, my lord kindly looks at the notification.
No, you give us this instruction.
Yes.
You give us that we can disperse the notional benefit bereft of the incremental advantage which is to be here. Give us that, we modify the order.
If yes, my lord, if my lord kindly gives me, my lord, 4 or 5 days time, my lord, to take that instruction.
You have taken this, Mr. Banerjee. Matter is running in the list. You are insisting.
Absolutely, my lord. Absolutely, my lord. In fact, last week I tried. Because my lord knows this.
This is an appeal.
Yes.
It's an appeal of the year
2023.
22. We are
2022. 22. Yes.
By this time, admittedly, both of them have added 65. They are also not appearing. They are also not appearing. Maybe that if they can only they can only say that there can be some enhancement in the pensionary benefits that will be done. You ascertain that, tell us, ask the court to clarify the issue, because the government circular intent and purpose is not seriously not intended to be going to, more so when the persons have returned.
Very well, my lord. Kindly give me within a week's time at the best, my lord. Let me, my lord, today itself I shall try to have the instruction, my lord. Because of, my lord, the situation regarding the appointment of VC in the university, my lord, some problems.
Mr. Maji, most probably you also do not know that whether any pensionary benefit, what had been the disbursement, what is the requirement. Maybe your clients are also not contacting. Otherwise, you would have got that instruction.
They didn't contact me because of the turmoil situation in the university regarding the appointment of my lord vice chancellor, as well as my lord some administrative problem regarding that my lord misappropriation of money and all this.
Like us of the present situation.
Yes.
That in view of the present situation, this issue of interpretation of the government circular becomes academic in nature.
Very well, madam. I shall, my lord.
You altered that portion.
Yes.
Recording that pensionary benefits on the basis of that be given. I mean, this was
yes. But kindly
this issue open as regards interpretation of the said circulars in a better case in future.
Yes, madam. But kindly speak it. No, my lord. My lord, keep it in next week, my lord. I shall take, my lord. Today itself, my lord, I'm trying to have the instruction, my lord, from the.
So as you do one thing, yes. 6 March, and in the meantime, you give a notice to the petitioners, and you come with the instruction.
I shall give notice to the petitioners, my lord.
Please give a notice to the lead petitioner respondent.
Yes. ইন্টারপ্রিটেশনটা করতে দরকার নেই, আমি একটু ক্লারিফাই করে দেবো।
Heard Mr. Banerjee, learned advocate,
Doctor, he is currently engaged in another matter. He's representing for the state. So if you could kindly.
Your lordships will be pleased to find the impugned order from page 59 to 64. Lord, may I, before my lord takes the matter, I can give in a nutshell, my lord, the factual matrix of the matter. I was appointed as an assistant teacher in Sanskrit on 10/7/2010. 10/7/2010. I had joined on 9/8/2010. Recommendation on 10/7/2010. I joined on 9/8/2010. DI approved the appointment on 1/11/2010.
Your appointment is through commission.
I was appointed through commission. Now, my lord, on 8th of September 2015,
Yes.
my lord, on 8th of September 2015, an honorable single judge of this honorable court passed an order directing the secretary of the managing committee and the headmaster to grant release order for attending B.Ed class. The issue which comes for my lord's kind consideration is
But 8 September 2015, what happened?
on 8 September 2015, an order was passed by an honorable single judge of this honorable court, my lord, directing the secretary and the managing committee, secretary of the managing committee and headmaster to grant release order for attending B.Ed classes, that my lords will be pleased to find from page 27 to 29. Now, significant feature of the matter, which is the most important thing and which was not considered by the learned trial court, my lord, I am just in
The 8th of September 2015, they were asked to release it. Then they did not release. Then what?
and my lord, your lordships may kindly take this date, 7/2/2013. My lord, I made a prayer for permission to apply for the B.Ed course, page 47. 7/2/2013.
Yes.
Then, secondly, I made another.
Then what happened? Then you moved inaction, you moved the
Right.
court said allow him to release him so that he can conduct B.Ed.
Yes.
Then what happened?
Now, my lord, it appears, my lord, that then, my lord, I was allowed to pursue the B.Ed course after, my lord, disregarding the representations at on 5th of February 2014 and 24th of February 2015. This is at page 94 and page 55. They did not, my lord, they did not permit me. There is a document. There is.
Now you said that he was permitted. Court's
What?
order to grant him release.
By an order of the court, after this order was passed by this court, then they, my lord, permitted me to, my lord, pursue the B.Ed course.
Then what happened?
Now, my lord, I pursued the B.Ed course. Now, my lord, it appears, my lord, that the second writ petition against which this order, my lord, has come up for my lord's in consideration. Kindly come to page 59 to 64. This is the matter.
So, what was your prayer in the writ?
The prayer in the writ petition was to the effect that, my lord, to set aside the order of the DI, my lord, which was passed.
Passed considering what?
The DI said that I have pursued my course. I have completed the B.Ed course in 2017. That is after 5 years. The requirement is I have to get the B.Ed course within 5 years.
So you were within 5 years means you
From from
pursue the B.Ed course and emerge to be successful.
Miller, that my lords may kindly consider.
Show us the order of 22nd January 2022.
22nd
DI order.
DI order, yes. Page Miller 48. Miller, I would be Miller requesting my lords Miller that I will be Miller only indicating to my lords Miller, kindly see. Yes, I'm sorry, Miller.
Court directed order passed by court on 8th September 2015.
8th of September, page Miller 27 to 29.
Then in the DI order is passing in compliance of court's order dated 6th March 2020. What is that?
Miller, I say Miller, the first writ petition, that is WP number 22038, which was disposed of on 8th of September 2015. The second writ petition, 8th of September 2015.
That their court said that you grant permission to do B.Ed.
Do the B.Ed case.
Then what happened?
Then Miller, your lordship may kindly consider that then Miller, the second writ petition is WP number 14130W of 2019. This order was passed on 6th of March 2020, page 30 to 31. So far as the instruction goes, I cannot say anything more beyond that. I should only. I'm sorry. এই 25 GAC টা কত পাতায় আছে? তো আচ্ছা ঠিক আছে, আর কিচ্ছু লাগবে না। Now, Milord, one thing, Milord, your Lordship may kindly consider. Milord, kindly come to page 48. The order of the DI. The order of the DI. Kindly come to paragraph 4B. This is the submission of the headmaster. The headmaster submitted as follows. The second is that the petitioner did not apply for permission for BA training course in the year 2014. Has my lord got it, my lord? Now kindly for a second, my lord, take the page to come to 3 papers. Page 47, page 94, page 55. And that এই জজ সাহেবের ওই কলম পড়ে গেল, কলম পড়ে গেছে, কলমটা পড়ে গেছে। Page 47 is a letter dated
That is of 2013.
2013, yes. 2013. Then, my lord, kindly come to page 94 and 95. 94 and 55. I'm sorry, my lord. 94 and 55.
These are all your representations.
These are all my, I have to, because when I'm working in the school, if I want to
pursue the course
of BEd within 5 years, because I joined.
When was your first representation?
First representation is on, my lord, page 30. Page 47.
But at that time, you could not have obtained the permission because 2 persons were already been sent.
See? No, on instructions.
Page 48, clause A.
Yes.
Has wrote for permission through her letter of 7th February 30.
Yes.
To undergo BA training in 13-4.
Yes.
Though meeting number such and such was decided as 2 teachers. The senior assistant were for the same in the same day, she was not permitted to undergo.
Kindly consider one thing. I say, my lord, only one thing. That this requirement of undergoing BEd degree, this is a statutory requirement which has been engrafted. My lord is well aware of, my lord, of the notice.
The school could not have left you because there was no, they already 2 senior most.
But my lord, they cannot at the same time, my lord, make a false statement in the before the DI. The headmaster is saying that the petitioner did not apply for permission for BA training course in the year 2014. Therefore, had it been a case that this statement is not there, then certainly, my lord, for the reasons of the for functioning of the
Presentation is not required because BEd is of 2 years at that time.
Yes, I say, my lord, kindly see 3 representation.
It was occupied.
My lord, kindly see, that's the reason I am showing to my lord. 47, then page 55. And
representation.
Yes, I have to take the permission from the school that grant me leave for pursuing the BEd course.
But how can they leave you when 2 persons have
Now, my lord, at the same time, can it be this way? Can it be construed this way? That, or my lord, kindly, I will be submitting two things. That, my lord, can I be faulted?
Come to the ordering pew now.
Yes. Now this is the matter. Now that's the reason I wanted to show it. Kindly excuse me for my interruption. Page 59 to 64.
No. What is the order?
59 to 64.
February 2020.
Yes.
Now then what is page 229?
Miller?
Oh, 229 is the direction to consider you?
Yes, in the earlier read petition. Yes.
27th February is the impugned order.
Is the impugned order.
You are still in service.
Yes.
But Milord, one thing I should be candid that at the same Mr. Topon Mukherjee is appearing on behalf of the state and ওর নামটা কি ওই যে তরুণ Mr. Torun Das is also appearing for the school. বল তুই সেটা বল আমি কি করে বলবো তুই বল তোর অসুবিধা থাকলে বলে দে আমার কোনো অসুবিধা নেই একটা ডেট ফিক্স কর মাঝখানে আমি ছিলামও না তাহলে অর্ডারটা পড়ছে অর্ডারটা পড়া হয়ে গেলে আমি চুপ করে আছি তুই বল যে বুঝু তুমি একটা দিন পরে নাও আমার কোনো
Very 2nd March 22 order.
2nd
March 2022.
2nd March 2022 অর্ডারটা কোথায় না না সেই অর্ডারটা কোথায় কত পাতায় Second March, your lordship has Milord gone into that.
This is page 62, recording of the judge.
Yes. Page 62 is the order, Milord, impugned.
2nd March 2022 order, because you are showing us page 48. That is 20th January 2020.
2nd March is the order at page 44. Page 44, subject to correction of my lords. ঠিক বলছি
44 is the circular.
সেকেন্ড মার্চের অর্ডারটা কোথায় এটা 44 না 49 একটু দেখি আপনি কি পেজ মার্কিং Milord, I made a wrong statement. Page 40, that will be page 49.
49 is 20.
This is the yes, 2nd March 2022. Yes.
At the page 48, it is stated
28th January, but Milord, these are the confusions. But I say, Milord, I after perusing this order, if your lordship ask me,
where was your first representation?
The first representation, Milord, only one thing, Milord, at the risk of repetition, Milord, I just kindly, Milord, permit me for a second. Page 63, page 63, the order impugned, which your lordship is now, Milord, which is before the judicial scrutiny of the court. Milord, kindly see that the observation of the learned single judge is, it is clear that the petitioner herself did not comply with the time frame stipulated in terms of clause 4 of the government order dated 12/2/99 as quoted. And now in order to dispel this doubt, your lordship is asking me that what is the first date of my representation? Page 47. The Lordship has already taken note of it. Page 47.
That inaction you did not pursue. Because 2013 you made the representation for allowing you to participate in the B.Ed course.
No. Kindly say, Miller, for a second, Miller. Kindly come to page 47. Page 47, kindly see prayer for permission for applying for B.Ed course.
Of which year?
This is of 7/2/2013. 7/2/2013. That's a thing. Miller, this was also troubling my mind. Kindly see page 47 bottom. 7/2/2013. This was received by the headmaster on 8/2/2013.
Then they were sitting tight over.
They were sitting tight. Then
the consequence thereof, you did not could not appear in B.Ed.
Yes.
Now you again made suo motu application. Now allow me to pursue the B.Ed.
Yes.
But that application was made.
That is at page. Kindly see this page, page 94. Page 94.
24th February 2015, page 55 also. 55. 7ই ফেব্রুয়ারি 2013, তারপর 15ই করলো, 14ই কোনো অ্যাপ্লিকেশন করে। সেই
ডেট নেই 94 এ।
তারপরে 15-17 কোর্সটা একটা wrong যে he did not apply. He applied but it was not pursued. And what will be the effect of that? ও নিজে accept করবে। Then why you are
page 94? Kindly come to Miller. Page 94, Miller, for my satisfaction, Miller. Page 94. The second representation. This, my lords, will be pleased to find this was made on 5th of February 2014. Received by the headmaster also on 5th of February 2014. To pursue my B.Ed course and to grant me leave. Then the third one is 24. Yes, Milord.
You're admitted, you made apply in 2013-2014. Application was made. Unfortunately, so 7th February 2013 order is at page 44, na? 47.
7 February 2013. That is at page 47.
This was considered for the session 13 to 15.
Yes.
But that could not be given since two senior most teachers were there. Now, she was not permitted in 13 to as per you, because they may be permitted in future after receiving her prayer. So in future 2014, you apply. Though the DI recorded, say you have
Not applied. Then also kindly see 2015 representation at page 55. What more, Milord, I can do as a teacher? As a teacher, Milord, I can only pray for permission
But the thing is, when this you did not,
দাঁড়ান,
7th
এক
of
second,
February
ধরে রাখো।
2013, representation was made. That was
Successively,
rejected.
yes.
That rejection was not challenged by you.
No, that not, they did not give any answer.
Page 48.
Page 40,
Date for permission to
page
letter of
48, Miller, just a
Right
second.
letter.
Yes,
7th
page
of
48.
February 2013 you applied.
Yes,
4A
4A, yes, yes.
to undergo for 13 to 50. ঠিক আছে? To meeting dated 2nd March 2013. This permission was refused.
Yes, yes.
After refusal on 2nd March 2013, you made a further representation. You are saying page 94.
14
এর পরিজনের আবেদন দ্বিতীয়বার প্রার্থনা এবং ছুটি মঞ্জুরের অনুমতি গত 7/2/2013 আপনার উল্লেখিত বিষয়ে প্রথমবার আবেদন করেছে যাহা আপনি মঞ্জুর করেন নাই। So 7th February order was not challenged by. Why? Because admittedly 2 persons were safe. Now you accepted that step and made a further application that you allow me to the correct answer. Complete the 2000
Yes.
there is that benefit from 2030.
No, I only say, I am just trailing behind on because of the order of the DI. Kindly see the order of the DI. The order of the DI, order the DI, kindly see the order of the DI, that is at page 40. I cannot read, I cannot, page 48, 49. নয়টা একটু পরিষ্কার করে দাদা লিখলে ভালো হয় না। Page 49, kindly see the penultimate or the Miller, the operative portion of the order of the DI. Petitioner joined the school as an assistant teacher of Sanskrit having qualifications such and such on 9/8/2010. I have nothing to say. The petitioner completed BA training in the year 2017 and I joined in 2010. Kindly see here, Miller, the observation is ultimately the petitioner completed BA training in the year 2017 and the last date of the examination was 14/7/2017 and the date of publication of the result was, Miller, I do not find anything.
Yes.
Now,
in spite of no lapses or negligence, her annual increment was stopped by the school with effect from এতটা এত।
no, I say, Miller, they are therefore annual increments was stopped. They do not say that no latches.
Page 49.
Yes, page 49.
5B. 5B.
Is it possible for a school teacher to come to court and to know the legal niceties, or to, I am working in a school, made a prayer, permit me to complete the B.Ed course. Then again, subsequent years also I go on making. Then what more I can do? I will come to a lawyer, take an advice.
What?
And kindly see this. 224 কোনটা দেখাচ্ছেন দেখান। আরে
এখানে করতে পারতো
224 কি হয়েছে? তখন বলবে তুমি কেন করোনি?
When did you ultimately complete B.Ed?
I completed it in 2017 as they indicated in
your prayer to want that incremental benefit.
Within 5 years, within the past 5 years.
You were appointed on 9th August 2010.
Right.
So
I have to do within 15. Within 15.
So you applied last moment 13.
13.
You
Even
got
if-
permitted, you could have completed within 15.
If
Permission was
yes,
denied.
I do not know if 13 is considered and the examination is held within 15, then I do it. Otherwise, I know I lose my chance. And kindly see also the particular order মিলন এটা অর্ডারটা কত পাতা আছে 12/2/99 এর অর্ডারটা দেখান তো কত পাতা আছে একটু দাঁড়ান
Complete করতে হবে। Complete করতে হবে। ইয়েটা বলছে this shall be allowed in a on condition have to get themselves trained. Get themselves trained, মানে ট্রেনিংটা কমপ্লিট করতে হবে। So last হচ্ছে 13, অ্যাপ্লিকেশনের লাস্ট হচ্ছে 13।
And also I have two more submissions and then I leave it to my lords. Kindly come to the notifications which they themselves have realized. 12th of February 1999 at page 108. The relevant portion is at 110. And there was an alternative in the particular ODL mode. This I
ODL mode,
yes. Yes.
Whether the BEd degree obtained through ODL mode would be accepted.
Milord, this is the government memo. I am being instructed. Milord, my lord will be pleased to find at page 224. Lordship is going more fast than me. Your lordship is going more fast than me.
No, in your
224, I
representation,
find that this is a notification issued by the government of West Bengal Higher Education Department. Kindly see page 224.
Mr. Bhattacharya, the admitted facts are you entered into service on 9th of August 2000.
I'm grateful.
Now 5 years takes you to 9th August 2015. Admittedly 2013-14 you were refused according to 2013 itself the resolution was taken 7th February 2013. That resolution, there is no illegality in that because senior persons were said.
But the notification does not say that. Kindly see the notification at page 108. Milord, I say, Milord, that if they want to invoke any particular thing, because
It was 12th of February.
That's I am showing page 108. That has not been incorporated. Had it been incorporated, I say, Milord, I cannot say anything more. This incorporation of a ground beyond the scope of this 12th of February 1999.
Did you challenge the resolution of 7th?
Milord, I did not challenge that. I am a school teacher. I am not aware of the legal niceties.
Legal niceties now. You are denied permission to do BEd.
Yes, on the ground that there are two other teachers.
When once you have been denied permission, you are not in a position to complete the BEd, no, though you apply. So 5 years period stands eclipsed. Within 5 years, admittedly, you did not secure the BEd.
Milord,
once you secure BEd, they are starting to give you.
Milord, I submit to my lords very respectfully that if there is any embargo or if there is anything to the effect that if some two teachers go for BEd, pursuing BEd, then the third teacher cannot go.
There is a circular.
They refer to that circular.
That circular, I am searching it out.
Milord, I could not find that.
You also referred.
You also referred.
Fifth, page 94.
I find, Milord.
Page 94, you stated that year, 2%.
They refer to the circular of 12th of February 1999, but they did not refer to any circular.
ODL মোডটাও নিতে পারছে।
Where in the penultimate paragraph, where they have referred to this particular circular, that because of this particular teacher, you cannot go.
Get themselves trained, মানে ট্রেনিংটা কমপ্লিট হয়ে যেতে হবে। 2 years ওইটা দুটো টিচার
2010 you were appointed.
I am appointed.
You did not take any step in 2010. 2013 you made.
After, since kindly see the date of approval of my appointment, that is at page 24, 1/11/2010. Before approval of appointment, I cannot do.
You know, so after 1/11/2010,
yes,
your first presentation which was made was of the year 2013.
Right, right.
2013. Now 2013 was dismissed by the resolution of 7th February 2013. You accepted. Thereafter, you made a further application.
May I say one?
Thereafter, you made a further application in 2014. You are showing us DI did not take into consideration. Then 2014 also you could not go. 2015 you again applied and you were sent. And you completed the training
In 2017.
Now from 2017 onwards you have been given the benefit.
Now I submit to my lords, your lordship may kindly.
But claim is that give me the benefits with effect from the date of my appointment.
Yes, yes. I should check up, my lord. I must not say anything.
The odd ODL and ODL.
না না অর ওডিএল অর্থাৎ রেগুলার যদি না পায় তাহলে ওডিএলও করতে পারবে।
Did you challenge?
Milord, I say, Milord, kindly see my prayers. Yes, Milord, kindly come to the prayers.
কিছুই চ্যালেঞ্জ করেনি।
I kindly come to
Now, where is that rule that maximum 2 teachers can be sent?
I did not find that.
That is there. You did not find.
Milord, I did not find that. Milord, kindly excuse me. It's my ignorance.
Yes, Mr. Das,
two teacher at a time from a school. Only 2 teachers can be sent to pursue B.Ed course, and 2 senior teachers. If junior applies, if senior said, junior will not get. Why that circular?
Have you brought that circular?
No, today I cannot.
So DI refer করেনি না?
ওই ইয়েটা কোথায় রেজলিউশনটা দেখি যেটাতে রিজেক্ট করলো ওই সার্কুলারে আরে রেজলিউশনটা দিন 35
Hey, clause C, what is page 948? Read clause C.
Page 48, clause
C.
Clause C.
Thereafter, the petitioner prayed for permission to undergo B.Ed training course in the year.
Clause C. Milord, it's not
C. Page 48, 4C.
Page 48, 4C. Yes.
There the circular date has been given.
Kindly see, Milord. এই জাসাকেটা দিয়ে দিন
What? That is a type copy.
আপনি Milord, no. আমি ভাই পাইনি
I cannot read it. 25-26
এটা কোথায় আপনি পেয়েছেন কি এই অর্ডারটা? না আপনি পেয়েছেন, আমিও পাইনি।
15 সালে 13 সালে কি 15 সালে
অর্ডারটা কোথায় কবে হয়েছে সেটা দেখা দরকার।
2014. Thereafter, the petitioner prayed for permission to undergo
meeting হয়েছে
in the year 2000. It 20
was approved in the meeting dated
নিজের application করি
15 approved করেছে, সেটাই বলছে আর কি।
In 14 he had not applied.
Even the February 2013 decision টা challenge করেন। On the contrary,
I made an application for permission on 5th of February 2014. 13 I applied, 14 I applied, 15 I applied.
Read clause C.
I have read it, Milord.
Clause B was petitioner did not apply for permission.
Milord, I cannot. I do not.
That is B. That I.
কোথায় আপনি আমাকে দিন?
After so much of argument, this time is taken that give me time to produce that. Should have said it at the inception. Thereafter, the petition.
একটা জিনিস আমাকে সার্কুলারটা দয়া করে দিন
2025 to
আপনি বলুন যে আমাকে মানে অরিজিনাল কপিটা দিন
No, Mr. Bhattacharya, you come to page 94.
Page
94, last part.
Sorry, just a second.
Yeah,
Page 94.
94.
94, Milord.
Second paragraph. Second
that-
paragraph, you says that
রেগুলার ইচ্ছাকৃত ভাবে
রেগুলার ওডিএলে একাধিক জনকে পাঠানোর সরকারি নির্দেশিকা ছিল।
So I could have been sent.
Where is that সরকারি নির্দেশিকা?
That has been Milord, page 224. Page 224.
In 2014, Lord, she took 180 days, 6-month leave. How you can go there?
Page 224, kindly see.
It is ODL method.
ODS.
So Bhattacharya, you did not challenge it at that time. On the contrary, you made a fresh application that allowed me to pursue the B.Ed course in 2015.
Milord, I'm grateful to my Lord. Milord,
You accepted that.
Milord, I am grateful to my Lord, but kindly see whether the order of DI, because your Lordship is kindly Lordship.
You are required to complete it in 5 years.
Right.
2013, your case was rejected to senior cert, right? Illegally. That decision was not changed. Just a moment. Thereafter, you made a fresh representation that allowed me to pursue the B.Ed course for 2015 to 2017.
Right.
That prayer was also refused. You were thereafter, even you did it from 15 to 17.
Why? Because by an order, when they rise from the slumber, they were sleeping in the particular slumber and they rose from the slumber when there was an order from the court. Is it an acceptable proposition that a teacher who is teaching, he will come to High Court and pass time over here and take opinion from the legal fraternity that what I am to do? He made an application. And Milord, kindly speak something more. Page 49. Kindly for a second, Milord, I repeat.
That means you are giving finality to the decision of the managing committee, not to be a permissive.
Yes, that is also
not permissive.
This is also not permissible. Why I say
The challenge that resolution.
Milord, kindly consider that DI ignored it. The DI ignored the resolution. Why I say
accepted that? Because you joined.
Kindly consider there are two sides of the coin. Lord,
you accepted that. You joined it in 2015.
Milord, kindly
completed it thereafter.
Milord, kindly for a second, Milord, kindly permit me. Milord, your Lordship is looking at one side of the coin. Your Lordship is looking.
You have annexed
on the your Lordship is looking to the anxiety of the school. But Lordship may equally, Milord, iron out the creases by looking into, Milord, the particular, Milord, balancing factor of the case. That is whether the order of the DI, Milord, speaks of that.
Page 29. What
Page,
you yourself has stated.
Page 229.
By virtue of which the DI order was passed. Read. That is an acceptance on your part. And in the second paragraph, and I have submitted on 22nd July, school has granted no objection, to admit in the B.Ed court. Provisional admission. 15, it is a final admission. As a result, petitioner on the presentation to the say for granting him with effect from 26 August 2015 to attend the B.Ed classes of 15 to 17. Unfortunately, did not release the claim for not attending the classes in the year 2003, hence the difference.
Yes. This is an intentional approach. Kindly see that language is very clear, Milord. If I may say so with my greatest respect and subject to consideration of my lords. I say, Milord, this is not a happy approach. Your Lordship is, Milord, while taking up the education matters, Lordship, you kindly consider, your Lordship in many matters are saying that why a school teacher is here.
You have to show us that there is no requirement of government circular. I have challenged the
No, why I say this is not. I say that the DI, kindly consider. I make submissions as a petitioner. He makes submission on behalf of the respondent. Your Lordship will now be ironing out the creases. Now, while ironing out the creases, if greater credence is given,
you yourself preferred a writ petition.
I say,
From 2000.
yes, that was when I had no remedy.
So then you do that.
I had no remedy.
ODL মোডটা চালু
That is at a stage when I have no remedy.
ও 13-তে ODL মোডও বলতে পারতো ঠিক আছে রেগুলারে আমি যাচ্ছি না
And DI did not give any credence. Kindly, at the risk of repetition, I am saying DI did not give any credence. Kindly see page 49, the operative portion of the order.
এই যে এটা দেখা
Yes, what do you say, Mr.
Miller, for a second, Miller, I repeat, page 49. Again, Miller, at the risk of repetition, kindly come. Starts from page 48. Your Lordship is indicating page 4, paragraph 4C. I say, Milord, that kindly see the paragraph 6 of the order of the DI.
Read clause C.
Yes.
Give it to him. Let him read. Let your junior read.
Pardon?
Q number 20.
No, clause C.
Yes, clause C, Milord. 6 clause C.
4 clause C.
48
Read it. Thereafter,
Since thereafter the petitioner prayer for admission into undergo BEd training course.
I can read it.
year 2015 to 16.
In mid-writing 96th of.
So that permission may be granted.
Yes, granted in 90.
This is a submission. For a second, this is a submission. But when the operative portion was born at page 6, at page 49, the operative portion was born in paragraph 6. Now, when this order was born,
Yes, then what is the wrong?
the wrong, I say, Milord, that the observation that a petitioner complete BEd training in the year 2017, this is on facts, I have nothing to say. But equally, I say that the previous occurrence of the events or the sequence of events or the particular representations which are submitted was not taken note of by the DI.
That is not to come earlier, Mr. Vartan.
Delay cannot defeat justice. Miller, that's the reason I say, Miller, this is an unequivocally the Supreme Court is saying.
How can we amend the rules now?
No, I am not saying for a second, Miller, for
From your date of appointment.
no, that's right. I am not saying
2010 to 2007.
Yes.
Then from 17 onward.
I say, Miller, the latches on the part of the headmaster.
Yes, Mr. That's what
পিছনে লেগেছিল বোধহয়
My lord has seen that the petition.
There was a criminal case.
But these petitioner, Lord, though it is or not, I am for the school authority. But they have challenged the order before the Honorable Single Judge. They have challenged the order of the District Inspector of Schools. Now they failed. The Honorable Single Judge rejected his prayer and the petition has been dismissed. So today I have not the record, but
rejected the prayer.
DI was rejected. That was challenged before the Honorable Single Judge. Honorable Single Judge, the order passed which dismissed the writ petition, which is under challenge before my lord. Now, Lord, today I have not got the record that these petitioner numbers of occasions he filed writ petition. Even he sought for the kindly give the resolution book, kindly the Xerox color copy. For that reason also she came to the Honorable Court repeated occasion. But that are not the issue here. She was not taking classes. She was not assess the answer script of this.
So you rejected his prayer since she was not taking
No,
classes?
not for that. But here the reason is not, he was appointed on 8th of August 2010. But that was not the permanent post, temporary vacancy. Now the post was written in the 9th of March 2015. Well, he applied.
On that, Mr. Das, you tell us.
Yes.
This observation of the DI, page 48, clause
Yes.
4C, B. Petitioner did not apply for permission for BA training in the year 2014.
Yes.
This is an erroneous record. Since the document at page 47 will show that he made it on 7th of February 20. This you did not consider.
ওকে একটা দেখুন এসে চেয়েছে ও কিন্তু পেছনে চাইছে না ডেট অফ অ্যাপয়েন্টমেন্ট থেকে ও চাইছে কিন্তু 15
But this is of 2013.
যখন ভর্তি হয়েছে
সেটা বুঝতে
হ্যাঁ পেজ 19 হ্যাঁ ও কিন্তু ডেট অফ অ্যাপয়েন্টমেন্ট থেকে চাইছে হ্যাঁ দেখুন
Mr. What is it? Page 19.
Page 19. Come to page 19.
Page 19. Setting aside the order of the DI, then Milord, by directing the respondent DI to allow the prayer of petitioner for releasing incremental final benefits from 1/7/2015 to 14/7/2017.
You have been given from 15 July 2017.
No, I say, Milord.
So you are not seeking from the date of appointment.
That Lordship was in this side, I must not make a comment. This is my last submission.
There is a typographical error. It was made from
Till 2015, she got the benefit. Huh? Yes.
What benefit?
So the B.Ed training qualification, the scale, the increment of the B.Ed from date of appointment. Yes, from date of appointment till within 5 years, she got, and within
completed 5 years in
after.
2015.
No, if she obtained the qualification by 2015, then it would continue. Now she obtained in 2017. So 16 and 16 was only one increment, 16 was not given. Then 17 it is continuing again.
recovery করতে পারবে না কেননা কন্ডিশন হচ্ছে তুমি 5 বছর তোমাকে ইনক্রিমেন্টটা দিয়ে যাবে এই 5 বছরের ভিতর যদি appointment was
The date of appointment is 9th of August 2010.
ঝামেলা করা উচিত নয় ঝামেলা করা উচিত না
পেজ 48
আমি page 48
কেন একসাথে কেন 5 বছর
Increment yearly July.
His approval of appointment was 1st November 2010. That is at which page? Where is his approval memo?
Yes, not his approval. Approval of appointment. Yes, page 24.
Which the printout is at page 33. Yes, his approval was
from the date of appointment 9th August 2010.
From the date of appointment.
Yes,
Maybe
yes.
approval will be 2 years, 3 years after 3
Yes,
years. But it would be
from the date of
back to the
joining.
date of appointment.
From the date of joining in the school.
From
the date of joining in the school.
joining was
Joined, well, he was joined on 9th of August 2010.
I joined on 9th of August 2010. Yes.
For 5 years, you gave him the benefit.
Yes.
Now, then it will take you to 9th August 2010. So 5 years will be 9th August 2015.
Yes, yes. But thereafter, before that, but because of that,
Not complete.
no, she could not.
5 years he could
No.
not.
Till 5 year it was given.
Was given.
Yes.
Thereafter,
It was stopped.
from 2015
15.
till he acquired the qualification.
Yes. Now 2015 was also given because 5 years will complete in August.
Yes.
Now increment is being introduced in July. So 2015 was also given that 5 years. Now in 2017 she complete. So only one increment in 2016 it was stopped. Again it was started from 2017.
Yes, he is correct. I say Millard only from 1/7/2015 to 14/7/2017, this was stopped. And that's why this prayer at page 19 in para 2 was made.
Yes, yes. Yeah.
As Milord Millard was indicating, Millard, that why this prayer, I say Millard that I have taken the instructions. And one more thing I should say, because though it's very embarrassing for me to say, but even then I'm saying, because I must not interrupt when my learned junior friend is appearing. Page 196. Kindly, Millard, for my satisfaction, kindly, Millard, read this the complaint which was made before the officer in charge by the concerned teacher, because there was a demand of a particular sum of money. Then there was institution of criminal proceeding, and I say Miller, I have taken the instruction that it was subsequently dropped. Our investigation. Again, Miller, there was an order of investigation. Kindly see this particular thing. This is my, I have nothing more to say.
হেডমাস্টারের সঙ্গে একটা লড়াই লেগেছে, যাই হোক হেডমাস্টার পুলিশ কেস হয়েছে। Based on that complaint, one criminal case was also started. The headmaster there, State versus Baroda. ODL মোড আমি অ্যাপিল করবো, সেটা আমাকে দিয়ে কথা বলতে পারবো।
So we yes, you want to say anything else?
Since he could not complete the B.Ed training within the time limit, within 5 years, school has been compelled to stop because the money is being released by the DI of school. And these 2 years has not been paid. Thereafter, after completing her the B.Ed training, she is getting the increment benefit in 2017. Others, whatever they have stated, those are not the issue involved herein.
What is the decision? Where is the decision of the school authority? You could have asked him to complete through ODL mode.
No, because the petitioner is the only teacher in Sanskrit subject. There are at least 70-80 teachers students are there. Not school is to be take not the arrangement for those students for the whole year. But she did not she shows the documents of 2014, but the from petitioner enjoyed the leave 180 days from 1st of April 2014 till 27th September 2014. 180 days she enjoyed leave. But if she obtained 6-month leave, how she can attend the how she can pursue her B.Ed training in 2014? And again, my lord, see 70 days, my lord, she took leave, my lord, from 10th of November 2014 till my lord, 18th of January. Within a 1 year, she took, my lord,
Excuse me, my lord. There is some mark post.
Specific provisionটা তলায় ডাকতে
Cross 4.
What is the date of the circular?
12 February 99.
99.
12 February is ROPA.
No.
This has been annexed in the
February
paper.
99 is annexed.
Yes,
It is annexed.
annexed.
It is on record. But where is that provision?
Untrained school teachers shall be allowed annual increments in the revised scale of pay. Conditions such unteachers will have to go to themselves trained within 5 years from the date of appointment.
That is, you rejected his case, who rejected his case by a resolution of 7th February, saying that they are two senior teachers, so we cannot allow it.
Yes.
That government circular that you are a senior
As per geo number 25 SU,
Or application shall be processed according to the seniority.
But relying on this 12 February 99, this prayer was rejected.
From the angle of the school authority, whether this decision to deny his permission, deny permission is correct or not. School authority says two senior teachers have already undergoing such course, so permission denied.
Permission would be dependent by the school authority. They are the best judge. Government cannot say how many teachers are there on the queue or those who are untrained.
Rightly or wrongly, that decision has not been challenged.
ডিএর অর্ডারটাতে ডিএর অর্ডারে লিখে দিয়েছে এই সেকশন মেমোর ভিত্তিতে ওকে অ্যালাউ করা হয় এই as per জিও নম্বর 25 একটা মেমো he was not allowed, she was not allowed, since there are in the pipeline.
পার্থক্য রয়েছে
একটু আস্তে আস্তে করুন না।
ওই
বুঝতে
decision
পেরেছি।
আমরা অনেক দিনে পিছিয়ে যাচ্ছি কিন্তু সেটা চ্যালেঞ্জ নয়
পেপার বুক আমাকে কপি দিস নাই কেউ
হ্যাঁ।
পার্থ আমাকে পার্থ পেপার বুকে কপি দেয়নি।
আপনি কপি দেননি?
হ্যাঁ আমাকে দেয়নি। কাকে দিয়েছে? কাকে দিয়েছে? কাকে?
আর ও শুধু ওইটা যে বন্ধ করতে সেইটা
রজত দত্ত তোকে দিয়েছে বলতেছে। Really.
Yes, please.
My lord, I beg to appear on behalf of the appellant in this. My lords, two issues are involved. Hmm. Right. Well, two issues are involved today before your lordship. Whether 5 years are mandatory for granting transfer on medical ground, one, and secondly, whether the 2002 rule applies for inter-district transfer or not. These are the 2 points involved before your lordship. My lord, first I draw your lordship's kind attention to the order impugned, which is at page number 91 of the stay application, dated 22nd April 2025.
Yes.
At the very outset, my lord, I draw your lordship's attention to the rules. My lord, kindly come to page number
Or show your application with your prayer in.
Yes, my lord. My lord, my application is at page number.
Have you challenged the violence of any provision?
No, I'm not challenged by
Where
it.
is that Shubhodip judgment?
Yes, it is in the compilation. দিচ্ছি, তোমাদের দিচ্ছি। May I just show my application first as your lordship had. Page 78.
Page
78.
on 7.
Page number 78 of the stay application. P.
Page কত বললি?
78. Dated 10th of February 2025.
Yes.
Patient written annexure.
That is within 5 years.
Within 5 years, I applied. That is my application. Now, my lord, kindly take the rules. Rule is at page.
There are two grounds of transfer.
Because I have categorically stated in the writ petition, due to this medical condition, I have having problems to travel this distance. That is a page, paragraph 3 of the writ petition.
We don't know what is your then prayer.
Medical ground. Medical ground is the prayer. And for that reason,
Since you are not applied.
no, only on medical ground, only to buttress my point that
Speak out properly.
medical
What
ground.
is your
Medical
application?
ground. Medical ground. I have given the
And not on the ground of
distance. No, medical.
Why did you say that?
Because I am having trouble to travel this distance for such
That is
medical
your
condition.
explanation. That is the ground for transfer is only for support.
Medical ground.
Gynecology.
Yes,
And
yes.
where do we find?
My lord, kindly come to page 17.
I am eligible for transfer since the residence and school is one.
16.
And I am suffering.
No, gynecology.
You are saying only on medical ground I have. That is not the fact.
No, I have applied because I have the medical records to substantiate.
Then your application does not say it's purely on the ground of medical. This is an application on two grounds. First is distance and second is medical.
My lord, only one thing, since there is no prescribed pro forma like secondary.
It is your letter.
There is
We are
no-
only trying
Yes,
to reaffirm from you that
It is on in my
distance and medical.
medical substantially on medical ground. In my paragraph of the writ petition clearly says that. May I place it? May I place the paragraph?
No. We
Very
are going by the records.
Yes,
This is
yes.
your application from
Yes.
which we have to.
Yes.
What is your explanation? That is not necessary. Now, which document you want?
Yes. My lord, kindly take the rules. My lord, kindly come to page 35 of the stay application.
Page 35.
Eachগুলো মার্কিং করো।
ঠিকই বলেছি জেরক্সে কি
My lord, kindly come to page 63. I'm sorry, my lord. Kindly come to page 63 of the stay application. Its pagination is not clear. 63. এখানে 63.
হাতে লেখাগুলো জেরক্সে আসে না।
এগুলো হালকা হয়ে গেছে স্যার। সুবিধা হচ্ছে।
Yes.
Yes. My lord, kindly take, my lord, this is the parent rule of 2002. Short title, the rule may be called the West Bengal Primary Education Transfer of Teachers, including Head Teacher Rules 2002. Kindly take subsection 2. These rules shall apply to teachers, including head teachers, for the purpose of transfer from one primary school to another within the jurisdiction of a council. My lord, kindly mark that portion within the jurisdiction of a council. Now, my lord, section 2B and C defines board and council. And the section 2, rule 2, subrule 2B and C defines board and council to distinct authorities. 2B and C. My lord, kindly come to the next page at page 64. Kindly take the provision for transfer at rule 4. Condition for transfer. A council may, kindly mark my lord, a council may Your Lordship, Rule 4. Rule 4, condition of transfer. A council may, kindly mark that, my lord, a council may, A, on its own motion, I come under B, on an application from a teacher, transfer approved teacher within its jurisdiction from one primary schools to another primary schools on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service, both in case of mutual or single transfer. Provided that the council may, if it considers necessary for proper utilization of service of a primary teacher in the interest of education, transfer an approved teacher without maintaining any time limit of service. That is not applicable in my case. So, my lord, it is a council. This condition has been given. Now, my lord, kindly come to the next page, page 65. Kindly take Rule 5, Subrule 3C. Subrule 3C. Second line from the top at page number 65. A teacher suffering from acute incurable disease like cancer, kidney ailment, etc., and such teacher possessing a supporting document issued by the competent authority. Now, my lord, kindly take Rule 6. Bar to transfer. 6.1. No teacher shall be eligible to apply for transfer for a period of 5 years from the date of transfer. Now, the first time the rule contemplates the 5 years bar from a previous transfer, not from the first transfer, for the first transfer. If somebody has taken transfer previously, there will be a 5 years bar from the last transfer. But for the first transfer, there was no bar imposed.
Also no provision that you can be transferred. You are saying condition of transfer 2 years continuous. Is a condition for transfer.
I'm saying this is for intra-district. That is my second limb of submission. I will be coming on later on. Only on medical ground, my lord, the bar is 2 years and
4B says 2 years of continuous service. Yes. Both in case of mutual and transfer.
Single transfer. That is for them to follow.
Yes, then what is your case? What is your argument?
I'm coming to that. My lord, now there is an amendment. My lord, kindly take the next page also. Now comes the inter-council transfer. That is the inter-district transfer. 8. Next page 8. Rule 8. In case of inter-council transfer, the council shall follow the principles and procedures of the board in accordance with the provisions conferred by the clause K of section 19 of the Act. This is for inter-council. The contention with regard with my second limb of argument that this rule is only applicable for intra. Your lordship has recorded the council may within rule 1. Yes, rule 1 sub rule 2 clearly says within the jurisdiction of the council. So this is only applicable if a candidate is applying transfer within the district primary school council, but not from one district primary school council to another district primary school council. For that, Rule 8 has been contemplated, which says in case of inter-council transfer, the council shall follow the principles and procedures of the board in accordance with the provision conferred by clause K of section 19 of the Act. That I'll be coming on. But now there was an amendment to this rule. Kindly take the next page itself. There is an amendment contemplated on 14th of September 2021.
14 or 13th?
ওপরে স্যার 14th আছে, এখানটা 14th, এখানে 13th।
গেজেটটা পাবলিসিটি
13th September, 14th September 2021. Kindly see from the third paragraph onwards. Now, therefore, in exercise of the power conferred by subsection 1 and clause K of subsection 2 of section 106 of the West Bengal Primary Education Act 1973, the governor is pleased to hereby to make with immediate the following amendments in West Bengal Primary Education Transfer Rule 2002. Now, my lord, kindly take at the bottom for clause B of Rule 4 substitutes the following clause B. 4B gets amended on 13th of September 2021. Kindly take, on an application from a teacher, transfer approved teacher within its jurisdiction from one primary school to another primary school on the condition that such approved teacher in case of mutual transfer is confirmed and in case of single transfer is confirmed and has completed minimum 5 years of continuous service within its jurisdiction, because 2002 rule is all about intra. So within its jurisdiction, 5 years have been imposed.
So and in case of a single teacher was amended.
Single transfer. They call it single transfer. The board, the authority calls it single transfer.
Calls what?
Any transfer other than mutual transfer is termed as single transfer in the rule. So there is no specification, there is no definition of single transfer, but my lord, how the law has been drafted, the single transfer. Possibly it includes the medical also, on medical ground. Now, my lord, kindly take the next page itself. There were certain modifications brought in through the amendment in Rule 5 also. Kindly take the middle portion. The grounds of medical grounds have
Your
been...
application was not, no order was passed on the basis of that.
No.
You directly approached the writ court for
Consideration and that order was passed.
So where is your challenge against the rules?
I need not to challenge the rules. I'm not challenging the rules. What I'm submitting, but I'm coming to that in the next phase, my lord. Kindly take the middle portion as I had shown the medical grounds that has been exponentially enhanced by this amendment in the middle portion. Kindly take sub-rule 3, substitutes the following sub-rules. Because your lordship may very well pose a question to me that whether the gynecological problem was there in the rule itself.
Your prayer was only for consideration.
Yes. And on the same ground, board has already allowed, I will be placing it soon. It has been allowed on same ground. Many occasions, by court's order, by voluntarily, by the board, it has been allowed. I will be showing to you.
What has been allowed?
This medical ground transfer under within 5 years has been allowed. In all occasions.
Where is that ground you have taken in your petition? Discrimination.
That occasion, possibly, my lord, that situation did not arise for me to stay because I only prayed for consideration. Because it was not decided by the board.
That said what? That as you have completed, as you have not
completed 5 years, we will not allow it. So
what you are showing next?
Yes, my lord. Kindly see the next page, my lord, the middle portion, sub-rule 3 substitutes the following sub-rules. Page 68. Next.
Sub-rule?
My lord, the middle portion C, sub-rule 3 substitutes the following sub-rules. It is an amendment to Rule 5.
The beta combined list showing the transfer in bold letter. This way it becomes very difficult.
Understand, my lord, kindly forgives me for this time, my lord. Next occasion, I will definitely come with proper.
The first occasion arose 1 month ago. Did not strike your mind.
Oh, my lord, I should have been more vigilant about it. My lord, kindly take the
blame is upon the court.
No, on me, my lord, absolutely on me. I should have come.
That sort of apology does not matter because ultimately we may have to adjourn the matter. You're smart enough to mention and insist for early hearing without coming the documents in the regular format. That is what we learn. That you satisfy the court by making a draft statement. Yes.
My lord, kindly take the next, my lord, at the middle portion. The middle portion, my lord, sub-rule 3 substitutes the following sub-rules. An applicant may seek transfer on the following grounds and same shall be considered by the council only against vacancy available at the time of consideration subject to the conditions made in sub-rule 3A in following order of preference, namely A. Any applicant or his or son, daughter, spouse suffering from malignant disease, severe heart disease.
Now, where is that unamended rule, sub-rule 3?
Yes, that I placed already. That is at page number 65. Second paragraph from the top. See. A teacher suffering from acute incurable disease.
This is rule 5.
Yes, this is the amendment to rule 5. Kindly take page 68 at the top. Under rule 5, this amendment has been introduced. In rule 5.
So the rule 5C earlier was acute incurable disease.
Yes, it was not defined. Now it gets defined. It incorporates the ground of serious gynecological disorder.
So read.
Yes, my lord. Any applicant or his son, daughter, spouse suffering from malignant disease, severe heart disease, renal failure, thalassemia, replacement of organs, serious gynecological disorder, which caused serious problem to attending the school. So this
exhausting
medical ground which has been explained, under which I come. Yes. Now, my lord, kindly take page number 70. There was an amendment to rule 8.
Yes.
My lord, kindly take the amendment for rule 8 substitutes the following. Inter-council transfer. Your lordship will find rule 8 at the parent rule at page 66 top and the amendment at page 670. Inter-council transfer. While considering inter-council transfer in accordance with the provision of clause K of section 19(1) of the Act, the board shall mutatis mutandis follow the provision of these rules, particularly sub-rule 3 of rule 5 of these rules, provided that the board may on basis of application or otherwise transfer any female teacher who is victim of crime with the concurrence of the state government in the school education department. It shall maintain due confidentiality regarding the duty of such victim. That is not applicable. Kindly see, it is in reference to section 19(1) of the Act. It is regarding the inter-council transfer. This is section 19(1). Now, your lordship has taken. Now, my lord, kindly come to the affidavit in reply filed by me on affirmed on 17th of September 2025.
You didn't reply.
17th September 2020. 17th September, page 330.
Yes.
My lord, kindly see, this is an order issued by the board itself.
You have given it in reply. How they will deal with it?
This board's order, I have given it in reply. It is board's order. The board
How they will deal with this allegation of yours? This is a new allegation you are making.
No, I'm just showing that on the same ground, before 5 years on.
Not incorporated in your writ petition.
No, because at that point of time, the situation did not
It
arise.
becomes a new issue which you are to have brought by way an appropriate application.
My lord.
How can you reply? You use a document which is not there in your writ petition.
Scope was not there before the honorable.
For that, there is a CPC provision available to you.
That has come subsequently.
For that,
Yes, I understand.
that application is required to be allowed.
I'm just only showing that why I'm showing 2002 rule is not even applicable.
Which page you are?
Page 30, my lord. Kindly take page 30 for once. Kindly take, my lord. This is of 11 September 2025. The board has received an application for inter-council transfer from Shompita Ghosh, assistant teacher, such and such, my lord. Duly forwarded by the chairman, DPSC Jalpaiguri. The applicant teacher is seeking transfer due to the following reasons. One, she is suffering from serious gynecological disorder. Second, her permanent residence is at Badinan district, Hooghly, which is a distance of 570 kilometers from her working place. The distance between her workplace and workplace of her spouse is 570 kilometers. So, my lord, considering this, the relevant portion kindly come to the paragraph at the bottom, which is very important. Considering the above and in terms of clause K of section 19(1) of the West Bengal Primary Education Act 1973, as well as clause 13 of the principles and procedures for transfer of teacher or non-teaching staff in a primary school between two primary councils, published by the West Bengal Board of Primary Education with a notification number such and such, dated 2nd of November 1991, Srimati Shompita Ghosh, assistant teacher, such and such school, is hereby transferred to the post of assistant teacher.
So she did not complete 5 years.
She did not. Her,
Where do we find that?
my lord, her appointment is, I'll kindly take one, serial number, 19th of July 2021. Now, my lord, serial number 1. Kindly take serial number 1. 19th July 2021. Now, my lord, kindly, the first takeaway of this order is that before 5 years on the similar ground, it has been allowed by the board. 1. Secondly, my lord, your lordship will not find any reference to Rule 2002. Inter-district transfer is decided in terms of 19(1)K, section 19(1)K of the Act, read with the principles and procedures for transfer. So 2002 rule is only applicable for intra-district, but not for inter-district, that the board itself follows the same.
He was transferred to another district.
Yes. At the very first line of the order.
So this is an order in terms of, according to you, in terms of rule. Which rule? According to which rule?
According to section 19(1)K of the Act of 1973, read with the procedures for principle and procedures for transfer. I will be placing it.
So 19(1)K. This is an inter-council transfer.
Inter-council.
You are seeking inter-council.
Inter. I am also seeking inter from one district.
One
district
council.
Yes.
Oh.
Yes. I am also similarly circumstanced. I am also seeking inter-council.
So you are saying there is no reference to which rule?
2002 rules, which I placed. 2002 rules your lordship has considered extensively. There is no reference to that because that rule applies for intra-council as per Rule 1, Sub-Rule 2.
2002 rules.
2002 rules, along with the amendment.
You say that not in respect of
inter-council, because the applicability itself says it is for intra-council. And council has been given the authority to conduct the transfer. which will be evident from Rule 4 itself, the council may, if your lordship has seen.
Was inter-council transfer takes part from the said rules?
No, inter-council is in the hand of board. Intra-council is in the hand of the concerned DPS. Inter-council board is the authority to grant transfer for within district. DPSC is the appropriate council is the authority. Now for
So that amendment also is not applicable to you.
No, that does not. Only to the extent
Amendment of 2002 rule,
does not apply to me.
which has expanded the scope
Yes.
from acute incurable disease of cancer or certain such to gynecological disease,
I understand.
also will not applicable to you.
For that Rule 8, which says that the procedure, the amendment in Rule 8 clearly says the procedure to be followed by the board, mutatis mutandis, particularly on these grounds. Procedure, in which way, what are the diseases to be considered, that has been amended in
Procedure prescribed in Rule 2002.
Yes.
Whether procedure,
Yes, my lord, the amendment says so.
1991, you come to
Yes.
the procedure.
Yes, I'm coming.
Whether such
Yes, it's there.
gynecological
That
disorder has been included or not.
Since there is a broad provision that the board has the power to grant transfer, that is why it has been stated, since the procedures and modicums have been given in the 2002 rules, that the board will follow as procedure. It is not mandatory but directly. Kindly take this Rule 8 amendment, page 70 of the stay application, the amendment to the Rule 8 for inter-council transfer. There was a provision made already in the 2002 rule for inter-council transfer, which says, page 70, page 70 of the stay application. Yes, kindly take Rule 8, inter-council transfer. While considering inter-council transfer in accordance with the provision of clause K of section 19(1)K, that is the parent act that has to be followed. The board shall mutatis mutandis follow the provision of these rules, particularly sub-rule 3 of Rule 5 of these rules. That is the procedure and modicum which has been given.
But you just now said that board in inter-council transfer, the rules are not applicable.
Yes, I'm saying that. I'm still saying that, but I'm submitting respectfully before your lordship.
The amendment refers to that rule.
Yes, that is correct. Why I submit, my lord? The board is not bound by the 2002 rules, which will be evident from Rule 1, sub-rule 2 itself.
Why? What does Rule 1 sub?
Yes, kindly take page 63 for once. Kindly take these rules.
The district council board will be the authority.
Yes, it is
that council.
Yes,
Inter-council, intra-council, it will be the council.
Council, it says within the jurisdiction of a council. So, Rule 2002 within the jurisdiction of a council. So, it is Rule sub-rule 2 of Rule 1, page 63. These rules shall apply to teachers, including head teachers, for the purpose of transfer from one primary school to another within the jurisdiction of a council.
For that, you are saying that inter-council, because inter-council is the power of the board.
Board under section 19(1)K.
But at the amendment, the board is also directed to follow Rule 3.
Yes.
Board will mutatis mutandis follow the provisions of sub-rules.
Particularly sub-rule 3.
You don't understand. Come to the point that 5 years barred.
Yes, I'm
wait.
My submission is this, my lord, your lordship has seen board has allowed below 5 years on medical grounds.
Yes, that we understand.
5 years bar is not there. 5-year bar is contemplated in Rule 2002. Since 2002 rule is not applicable for inter-district transfer, hence that 5-year bar does
How
not.
can you say that? That Rule 3 is not applicable to inter-council transfer because Rule 8 upon substitution includes the provisions of Rule 3.
Yes,
procedure.
Rule 3 is what? Rule 3 is the procedure. What procedure is to be followed?
So procedure will be followed, but the procedure which is within the rules will not be followed. That is your argument.
My argument is this, my lord.
It refers to board will apply the procedure
prescribed
under Rule sub-rule 3 of Rule 5. Does that lead to the conclusion that board inter-district council rules have other part of the rules will not be considered?
In my respectful submission, my lord, yes, the procedure, since the procedure of the inter-district transfer, there is a procedure, I'll be placing it. There is a procedure of inter-district transfer which does not contemplate such names of diseases. There is a broad power given to the board, read with section 91(K). Since it is absent in that procedure, therefore it has been stated as a directory that you can follow these provisions which is already given in 2002 rules. That would be evident from the procedure itself, because the procedure does not contemplate names of the diseases, how it is to be done. The procedure
Don't follow your argument. What you are arguing, we don't.
My respectful submission before your lordship is that, my lord, Rule 8 is subject to Rule 1, Sub-Rule 2. Applicability of the statute. Applicability of the statute is absolutely for intra-district. Now, when it comes to board, now what will board do? How board will deal with the applications of made on medical ground, on distance ground? How it will be done? The procedures and modalities that has been given under sub-rule 3, that these diseases can be taken. This is how the CMOH verification is to be done. So this part, the procedural part is to be followed by the board. But it does not, the rule does not apply to the board. My transfer application is to be decided. Now, my lord, kindly, your lordship was considering my affidavit in reply. I had shown page 30. I would also show page 28. Similar, below 5 years in terms of court's direction, that was voluntarily by the board, page 30. Page 28. Similar, I will not trouble your lordship to read the document. My lord, page 28 of the affidavit your lordship was referring to. I will not trouble your lordship, only it is in terms of court's order. Similarly, matter was pending before the authority, writ petition was filed. The Honorable Court directed to consider the application. My lord, the similar order was passed. I am not troubling your lordship, but it is only
Similar.
that page 28.
Somebody else's order.
Yes, similar occasion, matter was pending before the board, writ petition was filed, court directed to consider, it was considered below 5 years on medical ground, it has been allowed. That I'm showing page 20. Page 30 was voluntarily by the board, even in by court's order, board takes the same decision. That is also in reference to this 19(1)(k).
Yes, next point.
Page 29, serial number 7. That is also in reference to 19(1)(k).
Yes.
Lordship has seen? Yes. Now, my lord, kindly take page 30.
Non-teaching staff from a primary school within the jurisdiction of one primary school to a primary school within the another primary. So এটা কিন্তু ডিস্ট্রিক্টের মধ্যে একটা ডিস্ট্রিক্ট থেকে একটা ডিস্ট্রিক্ট নয়। Another
একটা district এর দুটো council হয় না।
just a problem.
Yes. Yes. Case 32, even below 5 years, in case of general transfer, board has allowed. Case 32 is an instance where application was made below 5 years on general ground, distance ground. That has also been allowed, because this bar of 5 years as contemplated in 2002 rule does not apply for inter-district transfer. That is why board has rightly passed these orders, and these are not 3, there are several orders. I've just incorporated 3 examples for all. That this 5 years bar comes under 2002 rule. Since 2002 rule is not applicable for inter-district, referring to 19(1)(k), under section 19(1)(k) of the Act, which is above the rule under which the rule was made, this has been allowed. But we have learned as a student of law that the statute is the parent and the offshoot is the rule. So since the statute being the parent, section 19(1)(k) has the application of the 1973 Act under which the rule has been made. So when power has been given to the board to grant inter-district transfer under section 19(1)(k), then the rule 2002 does not apply above the statute, creating a bar for me.
Yes.
Is one. Now, my lord, kindly take page number 20 of my affidavit. My lord, this is section 19 of the Act of 1973. 19(1)(k) is just the next page, page 21. The power of the board to grant inter-district transfer. To transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school to
Yes, we have seen that.
yes, 19(1)(k) I have shown to your lordship. Then, my lord, kindly take page 20.
19(1)(k) applies in respect of
Yes, under which all inter-district transfers have been given, which I am entitled to get, not under 2002 rules. Now, my lord, kindly take page 22, the next page, section 53. This is the power of the chairman of the concerned DP, page 22, the next page. Page 53, the power of the chairman, which does not give him power to conduct any inter-district transfer.
Power of the chairman of the council.
So he does not have any power to grant inter-district transfer. That's what I'm trying to portray before your lordship. Chairman does not have the DPSC, means it has to be channelized through the chairman. Chairman is the signing authority. He does not have the power. And page 23, that is section 106. This is the rule-making power of the state. 106(1), under which 2002 rule was prepared. Under this, the 2002 rule was prepared. I'm showing this for the reason that the rule being the offshoot cannot override the statute.
What you are saying?
I'm submitting, my lord, the rule, page 23, 106, section 106(1), subsection 1 is the rule-making power. Powers of the state government to make rules under which the 2002 rule was prepared. So, it being the offshoot, it cannot override the statute and section 19(1)(k). When 19(1)(k) specifically gives power to the board to conduct inter-district transfer, 2002 rules, being its offshoot, cannot override the statute and say that no, this rule is also applicable for inter-district transfer, because the statute does not contemplate so. And it has rightly been reflected in the orders of the in case of other transfers also. Only 19(1)(k) was referred, not 2002 rules, for this reason. Now, my lordship would also kindly take page 24, the next page. This is the principles and procedures for transfer of teacher or non-teaching staff in a primary school between two primary councils. This was published on 2nd November 1991, which is given at the bottom of the page. Your lordship has already considered that referring to this procedure along with 19(1)(k), inter-district transfer allowed below 5 weeks. Your lordship has seen that. So these are the procedures and modalities laid down. I draw your lordship's attention, if your lordship takes. Kindly take the second line from the top. It has 24.
Of the petition.
No, it's affidavit.
Reply.
Replies. Your lordship, kindly take the first paragraph itself. The following are the principles and procedures for transfer of a teacher or a non-teaching staff in a primary school within the jurisdiction of one primary school council to a primary school within the jurisdiction of another primary school council set by the West Bengal Board of Primary Education for the purpose of clause 3 of subsection 1 of section 19 of the West Bengal Primary Education Act 1973. Next, all transfers between any two councils will be guided by these principles and procedures. Then, my lord, kindly skip over a bit. Take this the second last paragraph, that transfer of primary teacher may be considered and effected by the board in the interest of primary education if and when the board is of the opinion that such transfer is necessary. So it is power of the board itself. Now, my lord, kindly take 10, page 25, clause 10. Clause 10, my lord, if your lordship kindly takes clause 10, applications of transfer may be accepted or rejected by the board And such decisions of the board will be final. Council has no role to play. Board is the authority for inter-district transfer. My lord, now kindly take the compilation of orders and judgments. The 2-3 things I need to show to your lordship. At the very outset, my lord, your lordship, while considering the impugned order, has considered the judgment of Shubhadeep Ghorai was referred to. I had placed reliance on the judgment of Shubhadeep Ghorai. Though, my lord, it has been passed in case of secondary transfer. Rules are different, definitely, secondary transfers. But the reasoning given in Shubhadeep Ghorai, which was very important, that why 5 years is not mandatory for medical ground transfer. For that reason, it was shown with the rider that it is, yes, it is for the secondary, but secondary transfer and the medical primary transfer, the grounds are absolutely similar and identical. That is why it was shown, my lord. Even for secondary also, on these grounds, transfer can be allowed. For primary also, these are absolutely same and identical. My lord, kindly take Shubhadeep Ghorai's judgment. That is page 1 of my compilation. It is of the Honorable Division Coordinate Division Bench. My lord, may I place it before your lordship? Paragraph number 2. The learned single judge has dismissed the writ application on the ground that the appellant is not entitled to pray for general transfer on special ground as he has not completed 5 years of service. The learned single judge has held that the period of 5 years mentioned in Rule 3 would be applicable even in the case of general transfer on special ground. We are unable to accept this said reasoning on the ground that a special right has been conferred in favor of a teacher to apply for general transfer on special ground, provided all or any of the conditions mentioned in Rule 4 is satisfied. In the event it is contended and held that period of 5 years is mandatory, then it would make Rule 4 nugatory, as the immediate purpose for transfer would be defeated, as the circumstances for general transfer of special ground required immediate intervention. To illustrate, a teacher or his spouse or his son suffering from thalassemia or any of the diseases under Rule 4 would be entitled to pray for transfer, and if it is denied on the ground that a teacher has to wait for 5 years, it would be fatal and a fait accompli for the teacher or his spouse or the children, as the case may be, and the very purpose of the said rule would be defeated. The Rule 4 is a standalone provision unconnected with the mandatory requirement of 5 years of satisfactory service contemplated under Rule 3 of the Rules to 2015. In view thereof, we direct the respondent number 2, the Commissioner of School Education, Government of West Bengal, to consider the representation. The logic of paragraph number 3, which I had borrowed from this judgment to satisfy this honorable court, that what is the purpose of this requirement of non-requirement of 5 years? Suppose, my lord, can we find Rule 4? Rule 4, yes, my lord. Kindly take. This is the secondary rules. রুলটা আছে আমার রুলটা কোথায় গেল may I just my copy the amendment of 8 September 2021 at the bottom, Rule 4A, just like it is in the 8 September amendment. I'm getting online amendment now. This is perimeteria with the rules, my lord. Absolutely similar and identical. So this is the logic, my lord, that if 5-year bar is imposed on me, then I have to either count my days in this medical condition or to wait for 5 years. This is not logical. This could not be the intention for a beneficial legislation of the legislatures. That 5 years has to wait, even if doesn't matter in which medical condition you are in, you have to wait. Even if you suffer extremely, then also you have to wait. Then the purpose is defeated. That is my humble submission, for which I relied on Shubhadeep Ghorai judgment. Because in perimeteria, similar rule, identical, this observation was made by the Honorable Coordinate Division Bench. Then, my lord, kindly come to page 7 of the compilation. Here, the Honorable Coordinate Bench applied transfer on medical ground before 5 years.
That's it.
May I place, my lord, paragraph 2. The application on the ground of distance filed before completing. This is, my lord, Madhumita Ghosh I am referring to. Page 7, dated 14th of May 2025. Paragraph 2, if your lordship kindly takes, the application on the ground of distance filed before completing 5 years service as a confirmed primary teacher is not maintainable in view of the amended Rule 4B of the notification dated 13 September 2021. And in such background, we are of the view that the learned single judge was justified in rejecting the said application. However, a submission is made on behalf of the petitioner appellant that she is entitled to transfer on medical ground irrespective of her tenure of appointment, meaning thereby it can be less than 5 years. And in this regard, the learned counsel has relied upon the judgment in Ria Bhadro versus State of West Bengal, dated 20th of December 2024. In this instant case, it is not an application on medical ground. Now, main paragraph 5, the dismissal of the appeal shall not prevent the writ petitioner appellant to make appropriate application for transfer on medical grounds. With this aforesaid observation, the appeal and the application are dismissed.
The application was not a medical application.
Yes, her application was not on medical ground, but the Honorable Division Bench allowed that even if you are below 5 years, you are allowed to make application on medical ground.
What does Rule 4B say?
Rule 4B, your lordship considered?
Amended Rule 4B
That your
of
lordship.
September.
Yes, my lord. Your lordship considered that is annexed at the writ petition, page number 67. The 5 years and 2 years requirement, page 67 at the bottom. Rule 4B.
Yes.
Yes. Now, my lord, kindly take. Yes. But kindly take page 9. This is the Honorable Coordinate Division Bench's judgment. That is Purba Da versus State of West Bengal and others. Mat 1245 of 2024. This is regarding applicability of Rule 2002.
Yes.
Yes, Manoj. Kindly take paragraph number 1 onwards. Though there is no reflection of any provisions putting a restriction and or embargo of 5 years in seeking transfer, yet it can be reasonably inferred that what weighed to the single bench was Rule 6 of the West Bengal Primary Education Transfer Rules 2002. Rule 6 of the said rules is explicit that no teacher shall be eligible to apply for transfer for a period of 5 years from the date of transfer, which according to the learned advocate for the board is extended to 7 years. Such being the undisputed facts discerned in course of hearing, the first and foremost point which arose before us whether such rule has any manner of applicability in the facts of the instant case. The said rule is promulgated in exercise of powers conferred under clause K of subsection 2 of section 106 of the West Bengal Primary Education Act, containing exhaustive provision relating to the transfer of teachers, including the head teacher. Subrule 2 of Rule 1 of the said rules clearly indicates that the said rule shall apply to the teachers, including the head teacher, for the purpose of transfer from one primary school to another within the jurisdiction of a council. It is explicit from the aforesaid provisions that the aforesaid rule has its applicability to a transfer from one primary school to another within the territorial jurisdiction of the respective primary school council and does not expand its horizon to a case of transfer from one territorial jurisdiction of a council to another territorial jurisdiction of a council. The aforesaid provision appears to have been overlooked. Had those been brought to the notice of the single bench, probably the said order would not have been passed. It is no longer res integra that the moment this subordinate legislation or the substantive legislation is promulgated to operate within a limited contour, its operation cannot transgress such limit. but has its applicability within such limited sphere. The stand of the council that an embargo of 5 or 7 years is created in processing and application does not appear to be in consonance with the law applicable in this regard. Our attention is drawn to section 19 subsection 1 clause K of the West Bengal Primary Education Act 1973, being the repository of the powers and functions of the board, including the power to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school council to a primary school within the jurisdiction of another primary school council. Such power is vested upon the board in case the transfer is sought from one zone to another, or in other words, from the primary school situated under one primary school council to another primary school council, and therefore, in such situation, the respective primary school council does not have any powers or the jurisdiction to deal with such application for transfer. The executive instructions in the form of principles and procedures to process the said application is also subsequently notified by the Secretary of the Board, video notification number such and such dated 2nd November 1991. It contains an exhaustive provision relating to the principles and procedures to be adopted on an application taken out by the teaching or non-teaching staff of a primary school seeking transfer from a school situated within the jurisdiction of one primary school council to a school situated within the jurisdiction of another primary school council. It does not contain any embargo like the one appearing in the said rules, and therefore the order assailed in the instant appeal based upon the said rules, which lacks its applicability to the facts of the instant case, is unsustainable. The impugned order is thus set aside. The Secretary of the Board is directed to consider the said application in the light of the said notification dated 2nd November 1991 as amended from time to time, and conscious decision shall be taken within 4 weeks from the date of notification.
Now, how did the single judge?
চেক করবো না যে ও সত্যি করে আছে কিনা।
How did the court deal with this?
Yes, but only one thing. I don't know whether I'm right in placing this before your lordship. The same bench in the similar issue has allowed transfer. The same circumstances, that is the first judge.
That's how the court has dealt with.
Yes, allowed.
Portion of the order, how?
The impugned order your lordship is referring to. Yes. Page 91.
And regarding Shubhadeep, what is this?
Shubhadeep Ghorai, my lord, kindly take page 92. The first paragraph itself. My lord, kindly skip a few lines. Shubhadeep Ghorai starts in support of such a submission. Reliance is placed on the order dated 24th August 2023, passed in intra-court appeal being MAT 782, Shubhadeep Ghorai. Relying on order dated 24th August 2023, it is submitted that Honorable Division Bench has held that Rule 4 is a standalone provision unconnected with the mandatory requirement of 5 years of satisfactory service as contemplated under Rule 3 of the West Bengal Rules 2015. Therefore, decision in Shubhadeep Ghorai is applicable in the present case in order to permit the petitioner to take transfer on medical ground, though petitioner has not completed 5 years of approved service. Your lordship has found. My contention has not been referred to that 5 years, why it is not mandatory. Then, my lord, discussions have been made. Because there was a distinction made between the rules, though it is pari materia.
No, therefore, the decision in Shubhadeep is applicable in the present case.
No, submitted.
I stated that the paragraph speaks of
now where is the reason?
reason. Yes, having considered the submissions made on behalf of the parties, this court is required to find out whether ratio of Shubhadeep Ghorai Supra is applicable in the present case or not. The decision of the Honorable Division Bench in Shubhadeep Ghorai Supra is in the context of Rules 3 and 4 of said Rules of 2015, which is applicable in the case of teachers working in secondary schools. This is one. Secondly, moreover, in the subsequent notification dated 8 September 2021, amending said Rules of 2015, under Rule 6, exception has been carved out in case of application seeking transfer on medical ground, but the case at my hand relates to transfer of a primary teacher which is required to be examined in terms of said Rules of 2002 as amended with a notification dated 13 September 2021. Under Rule 4B of the said rules of 2002, as amended with a notification dated 13th September 2021, it has been specifically provided that applicant teacher in case of single transfer has to complete minimum 5 years of continuous service, being a confirmed teacher. Unlike provisions applicable in case of secondary school teachers, as provided under amended Rule 6 of notification dated 8 September 2021, amending said rules of 2015, no exception is carved out under the said rules of 2002, as amended with a notification dated 3rd September 2021, for considering transfer application of a primary teacher made on medical ground. That much. Now, my lord, my contention was to show in Shubhadeep Gorai, the Honorable Coordinate Bench has categorically held that why 5 years not mandatory. If someone is suffering from thalassemia, if someone is suffering from cancer, whether he should wait for 5 years or he should suffer for these long 5 years with that medical condition. That was my intention. The ratio decided by before the logic, the soul of the judgment I had to
So in
place.
secondary teachers, rules are applicable in full flow. These rules of 2015.
2015.
No, these transfer rules.
Yes, 2015 rules. Secondary.
Case of secondary teacher.
Yes.
Rules which are applicable are
Secondary, I've handed over the rules, secondary rules. This is primary.
No, the amendment of the rules which were amended. Those rules are applicable to secondary.
No, the amended rules are perimeter.
Amendment rules are also under primary.
In both secondary and primary, rules were amended. These are verbatim, perimeteria, similar. I can show from the rules on medical ground. These medical grounds, these 6 medical grounds, including
in Shubhadeep,
yes,
court proceeded on the basis that this court said that that is in relation to secondary schools.
Secondary schools,
not in case of primary.
But
that issue was not discussed in the judgment.
No, that logic, that why 5 years has been recorded in the division bench's order, that why 5 years is not mandatory, that has not been discussed by the honorable single bench in the impugned order. One. Secondly, though the honorable single bench held that this is regard
have discussed saying that the rules under the secondary schools, that judgment was passed.
Yes.
In respect of a secondary,
Yes.
but if it is passed in a secondary, 5-year bar is there in secondary as well as in primary.
Primary. That is
now the secondary rules. So in respect of this is the West Bengal primary education rules. What is the secondary school rules guiding the transfer?
Yes, that I have handed over to your lordship. The two compilation. May I just take this one? May I just take one copy and show the, my lord, I'm just lacking this document with me somehow. May I just, my lord, I'm very sorry. I just have 2 copies of this. I'm just showing you.
Now this rule and the amendments are perimeteria.
Perimeteria. That I'm showing. Absolutely perimeteria. Kindly see.
All right. Yes, Mr.
May I just show the perimeteria?
That is admitted.
Yes.
Opposes that?
Yes. Only one thing, my lord. These on the same ground as I submitted, I have also given the judgment. The same bench, same issue, allowed transfer below 5 years. But in
that be a ground of appeal.
No, I'm just showing that same source, 2 different flows. That I've given the compilation. Extensively, it has been very nicely, my lord, it has been discussed. Kindly take the page 4 of the compilation. Shabana Khatun, 23rd December 2024. There was a direction even for consideration of this application.
No, it is it is on medical ground.
Same.
It is on medical ground.
Medical ground below 5
But
years.
the court, in the given case, court
Yes, it is similar.
notice that your first count, or court noted in the order that first count is discharge. Second count medical count.
My lord, since there is no prescribed pro forma, unlike secondaries transfer, there is no prescribed pro forma for primary. So, my lord, applicants may write in their own way. It is not they have omitted their ground. They made application on distance ground, seeking transfer on medical ground. No, it is there. It is in their way of writing they have written that my distance is this, and my lord has seen the board's order.
No, when distance ground, then 5 years bar will apply, even if your submission is accepted.
Board has allowed this kind of transfer.
What my brother is saying, that your application in its totality is an application for transfer from distance ground and second on medical.
Composite
It
application.
has been written in that way, my lord, since there is no prescribed.
You're wanting.
Yes, yes. Because my lord.
Then why, while applying on medical ground, why should I say that you are transferring this 170 this much of distance
No,
from?
not required. Not even required. Only to substantiate that in such medical conditions, she is not being able to travel that long distance. My lord, understand gynecological problem, she can't travel. That is
it is coming from wise vein or
no. Well, I'm being very honest with you,
paternity.
this, since there
When the legislature has categorized the application,
yes,
application on medical ground,
yes,
and application on other ground,
yes,
distance or other ground. Then if both the grounds are joined in this one application, then how that application will be interpreted?
Because the procedure has been given in section 3.
I mean, he is teacher, not said he is teacher.
Yes, my lord. It is in there.
It is
Since
not
there is no prescribed procedure.
layman, illiterate person, not that.
Since there is no prescribed procedure, they write in various manners. And my lord, section 3F is given in the rules for conducting medical verification by the CMOH. There is a specific procedure given. So, my lord, that is in her way of writing, my lord. Kindly do not go into that in
Application under which
medical ground, because I've given the medical documents also.
The application.
Yes.
Your application page 78.
Yes, my lord.
I am seeking transfer. I am eligible to seek transfer on two grounds.
Yes.
One ground is distance, second ground is medical.
Only 1, 2, she has written in that way, my lord. That does not take away her medical ground. It is there. It is not that she has not written medical, but still asking for medical.
That is not your argument also before the lead court.
No,
I treat it as a application for medical.
No, that is recorded, my lord. Kindly see, my lord, that is recorded. My writ petition paragraph. Kindly take, my lord, paragraph 3 of my writ petition. Kindly take, my lord, what I have stated in paragraph 3 of my writ petition. Well, kindly take page.
Now you come to your application,
yes,
page 78.
Yes, my lord. Absolutely.
Now come to the third paragraph.
Yes,
now presently.
I am eligible to speak.
Presently, the word presently speak about the time.
Absolutely. Correct.
Presently, I am eligible.
Yes.
That means now I have acquired the eligibility.
Yes.
Read in this way.
Yes.
To seek general transfer.
Yes, my lord.
Okay. So after a certain point of time, I have acquired eligibility to seek transfer. So it speak about 5 years bar or any time bar.
My respectful submission.
Now slash is or transfer on special ground.
My submission is that
now reason, distance,
yes.
Second transfer.
That is her way of writing, my lord. That does not take away that ground of medical.
Yes, Mr. Sir.
Lord, should I deal with a little factually, or my lord, should I deal with my lord points of law first? Because my learned friends argued on points of law. The 2002 rules not at all applicable in case of inter-council transfer. That's the point. But I find that submission is self-contradictory. If the 2002 rules is not at all applicable, then my lord, the board doesn't have any power on medical ground to transfer.
Sandal, this 5 years bar, you are serious about it, or we sent it back?
My lord, if your losses ask me as a counsel, I'm serious. But if I am as a junior counsel, but I have to interpret the law, my lord, as a senior counsel. I cannot.
The finding has not been clear. The petition was filed alleging inaction.
My lord, I tell you, consider. I tell you, losses, because this was rejected on the point of law, rather. Now, what I am telling you, losses, we have explained in our affidavit in opposition in regard to the transfer application. Now, your lordship has to consider the present.
No, Mr. Sandhan, we are just, we will hear you. We are trying to think that if suppose without answering this point of law as has been urged, which he did not have the impression to urge also before the single judge has come. So avoiding that issue, we can send it.
No, I think that will be tyrant. That will be tyrant to the authorities of the board. That's why the state has framed the rules. Your lordship has seen 2 orders absolutely illegal against the law.
What have you done?
Well, that's your lordship. That's the point. That's why I'm saying, Lord, as a senior counsel, I can't. If your lordship ask me interpretation of law, I have prepared myself and I will answer to each and every question of your lordships. Before that, I take your lordships, my lord, to the. That's the tyrant. My lord, rule is not offsuit.
We didn't follow you. What is that? Is the tyranny.
Tyrant attitude will be what they will do, somebody they will give, somebody they will not give. And that they have done, the secretary. I asked my junior, how could you do this against the law?
You withdraw those orders.
Well, those others have been given effect to that, my lord. Negative equality cannot be. My learned friend is citing the discrimination. That's negative equality. That's I'm saying. Your lordship has to interpret now. This is the highest court of the land to interpret the law. Now I will take your. No, law is Malla has to be. Your lordship for the ultimately law has to be decided. Otherwise, Malla, thousands of applications are there. Why the 5 years limitation has been put by the legislature, I have to explain.
No, what he is saying that in respect of inter-district transfer, there is no time limit. And the board has not treated that a time limit required to be completed.
Well, that's wrong.
Making application.
That's wrong.
And
why I'm saying your losses.
Support of his submission, he has cited some.
Kindly. Kindly take up her application. Why the law is correct, I will demonstrate right now. Application for transfer. He was appointed on merit, on the basis of merit from the state list, as your lordship by this time has come across the position of the recruitment rules, district-wise panel, state-wise. On the basis of merit, she was appointed from the state list, merit list, in the district of Malda. Her matrimonial district, I tell you, state-wise merit list. I tell you, lordships, district-wise merit list is prepared. First, the common state-wise merit list is prepared. 2016 rules have been amended, your lordships. Kindly do not carry any impression of 2016 rules. That has been subsequently amended. 2016 rules was, your lordships, each district separate. No, primary. Primary also. Your lordship has 32,000 matters have dealt with. All that, your lordships, I just give your lordships on the basis of merit. Now, merit, her own district was district of Nodia, matrimonial. If I am not incorrect, her paternal home also Nodia. But she got appointment on the basis of merit in Malda, not her own district. Now, merit, your lordships, someone gets 21 in the year 2021. In the next year,
that he on merit he was in.
Malad, your losses kindly come to page 78.
So he obtained what the district of Malda.
Ultimately, Malad, initially might have in the Nodia, she could not. She did not. Therefore, Malda. Whatever your losses, on merit, he got appointment in the district of Malda. Your losses will find it, the pursuant to appointment letter, I was appointed as an assistant teacher of Khalidpur MGD Primary School, and I joined that school in 2021. Merit, she got the appointment, Nadia. Now, within 1 year, if there is no limitation of 5 years, she will apply on medical ground, being me in my own district. Now, what we have stated, I will take your losses, the governments. Take example that she is suffering from gynecological disorder. If one cannot get treatment in the district of Malda, I am putting a question to myself, how can it be treated in district of Nodia?
Not about the
Malad,
not about
No,
the
no.
treatment. With such disease, he is unable to take travel to.
Oh, Malad, I tell you lots. I take your losses. Every teacher is getting that is called house allowance. She is drawing house allowance for Nodia in Malda district. She has to accommodate her own residence. It's a public service. That's why the rule has been brought by way of amendment. Because this was not initially there. Rule has an object.
What was brought in the
Brought in 5 years limitation, because tomorrow I get appointment in this district.
initially there?
Not there. That's why the rule has been placed.
That the
2002 rules initially. No 5 years, 2 years there. Rules, 2 years.
So she got herself selected on the basis of which SLST?
This is not SLST, but primary. If I am not wrong, 2020 recruitment process. 20.
So in that 2020, there was no bar.
No, it's a recruitment rules. Bar in the transfer rules. I am explaining before your lordship why this bar. Then, my lord.
Understand. Transfer rules, corresponding transfer rules applicable to recruiting under 2020.
2002 as amended up to date. 2002 rules as amended up to date. Because amendment was also your lordship in the year 2021, 14th September. So what I am trying to explain, I have explained.
2020 when it was amended, being in that
5 years.
After 19.
19 years. Because the rules also new. 2020 the rules came into force. Amended rules. 2016 rules was amended.
Yes.
Now the object is that someone gets merit in Y district by way of transfer. He come on the medical ground, he cannot be brought in another district, which he didn't get. And apart from teacher pupil ratio, that's also another aspect. So, my lord, this is that point, your lordships. If one cannot get in a medical treatment in one district, how can he get in another district, my lord?
Not she transferred to Nodia.
No, yes, Nodia. Yes, your lordships will find last column that the above conditions are valid grounds for transfer under the realm. I'm saying district Nodia. So everybody will do that. The merit is compromised. That's why, my lord, one has to stay for 5 years. Medical cannot. I'm prompted to say one thing, your lordship, but your lordship probably, particularly Justice Chakraborty, will not like me in that. If I utter them in respect of transfer. Now, this is one try for transfer. I was, my lord, defending the
pair is subject to accept of the medical person. Doctor.
That's your lordship. My lord, I come to that. No, I come. That's another, my lord. That's, my lord, can be. But point is before 5 years. Now, suppose he is, my lord, a crude example, cancer. But can he not be treated from Malda? If one can be treated from Nodia, can it not be treated from Murshidabad?
It is not whether there is a treatment facilities is available in that district or not.
Then what?
It is that whether with this disease, acute repetition, whether this person will be able to travel.
My lord, that's why I'm saying, your lordships, he has to stay in the district of Malda. Having received the appointment, drawing the house rent allowance, how could one say? He's not going, going from Nadia. She's staying over there.
All right, come to your opposition. What is your?
That's your lordships. My lord, kindly your lordships. Opposition.
Respondent number 8.
This is factual. Then I will go to your lordships, the rules.
Your opposition?
Yes.
Opposition.
কৌশিক এটা কার দিলি অভিষেক প্রসাদ আপনি নিয়ে নিচ্ছেন তুই দিয়ে তুই তো দিতেও পারছিস না এই তো দাঁড়া
Opposition by Partha Karmakar?
Yes. Lord, I take your lordships, paragraph 4A, page 2. First the simple denial, then I specifically state that the petitioner, on the basis of counseling as per her merit in the panel position, had chosen the present school, and she was appointed as assistant teacher on July 17, 2021 by Malda District Primary School Council. Having accepted such appointment, the petitioner is now asking for an inter-council transfer within 5 years of her appointment. The petitioner, having been appointed on the basis of her counseling and merit position in the panel, cannot now raise the point of distance from her matrimonial district Nadia to her school at district Malda under Kaliachok South Circle. It is obligatory on her part to secure her residence within the nearby location or area of the school, and she cannot cite the distance of 160 kilometers from her matrimonial district to the district where she has been appointed. The petitioner applicants also gets and draws house rent allowance in accordance with the revision of pay rules, and having drawn since LC cannot raise the point of distance of a transfer. The petitioner sought to make effective as ground of distance of a transfer. I also submit on her own saying the residence of the petitioner is in rural area, namely Sisha, Dahodaria district, Nodia, where her present posting of the school is at Bahadurpur, Kaliachok Circle district, Malda. Petitioner wants a transfer from Bahadurpur, Malda district to village Sisha, Dahodara area, and for this purpose he has mentioned 3 schools in the nearby location of her residence in the Nodia district. It is unbelievable that the petitioner is not getting medical treatment facility in Malda district, but she will get her facility in a remote village in Nodia district. The factual matrix makes her application basically and fundamentally on the ground of distance as well as the special medical ground, and therefore the bar of 5 years is attracted. These also substantiate that the alleged disease of the petitioner is an excuse, and for such an excuse, transfer should not be allowed at the cost of primary education. As she can get medical treatment in the rural area of Nodia district, she can also get the same in Malda district. Inter-district transfer on special medical ground may be exercised sparingly in a most urgent and serious case where medical treatment at the facility is not at all available. This is not so at all in this case. The very object of imposition of bar of 5 years from the date of appointment is to protect the merit position.
Interrupting you for a moment, so you admit that inter-district transfer on special may be exercised
Sparingly. Yes.
So then 5 years bar goes.
No, in inter-district transfer itself, not on the ground within 5 years, even after 5 years. Sparingly means, my lord, whatever it is, my lord, can be considered. It's not that a matter of right.
This sentence itself shows that 5 years is not a bar.
No, my lord, that kindly, my lord. First, this also substantiate that kindly. That's, if I sentence kindly, my lord, the entire, then I will again repeat. The very object of imposition of bar of 5 years from the date of appointment is to protect the merit position, and posting obtained by a candidate on the basis of her counseling and merit position as per the recruitment rules. And the event of allowing this sort of transfer before 5 years, the purpose of recruitment rule will be frustrated, and with regard to its merit and counseling amongst the candidates. If we read together, sparing means even after 5 years it can be done sparingly.
That is your.
That's your. That's submission.
That is your.
This part is entirely submission.
Mr. Sandal, this can be done. You can take it as a. It is sparingly.
All the applications before 5 years. All the applications are before 5 years on medical ground. All. Now that's why I'm telling you. Pardon me for saying that. One application was moved on this ground, whatever the present ground. The honorable judge was a lady judge. She says every lady suffers from these ladies, and this can be allowed to be transferred. Now all the ladies to be transferred. It is not, my lord, that. Now suppose a teacher posted in Nadia, he's suffering from cancer.
What is your next point?
Now this is, my lord, the factual. Now I am taking your losses to the position of law. Now I take your losses to the act itself first. তাহলে কি করে দেখাবো? Rule 2, Act Section 2, subsection XX, that means 20. Roman X. Your lordship will not get it in any of the
No,
pleadings.
he has annexed the.
That's section 19 only.
Oh, acha. What you're showing?
Malad, section 2, subclause 20, Roman XX. I think your lordship, it's normal in every act. Prescribe means. Prescribe means prescribed by the rules or notifications or orders. That's
Section 2 XX.
XX of the act. Now your lordships kindly come to section 19. My learned friend has annexed. What page?
Page 21 of the affidavit.
Page 20 or 21?
20.
20, man. Lord, I will be a little slow because I will not be so. Lord, first, like my brother, subsection 1. Lord, kindly see the very Lord, starting of the section. Subject to any general or special orders of the state government. I request your lordship, this has to be read with prescribed definition. The provisions of this act and any rules made thereunder, the board shall have generally the power to guide, supervise, control primary education, including primary teachers training, and in particular the power. What is the power my learned friend has shown you to your lordships? K, to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school to a primary school within the jurisdiction of another primary school. My learned friends, the argument, the board has exclusive power, not that. Board's power is subject to the rules, notifications, and orders of the government. Why, my lord, this has been done? Otherwise, the board will be tyrant in exercising its powers. They will be capricious in exercising, and they have done it. That's why I'm saying, my lord, all these submissions I'll be making as a senior counsel. What is the interpretation of law? It might go against some of the officials of the board. I don't care that. But this is not the law. Law is, board's power is subject to the rules.
Yes.
That's true. Then your losses kindly come to section 60. Section 60 to Joseph da paben na. Oh, I to arakta boi din Joseph.
Section
60. 60.
Section C, what does it say, Mr.
My lord, I have shown to your lordships power of the board transfer from one council to another council that calls inter-council. Now inter-council power. Intra-council power of the council. So your lordships kindly look at this, section 60. It shall be the duty of every primary school council. Then your losses straightway come to clause K again. Subject to the prescribed conditions, to appoint teachers and other staff in primary school, to transfer any such teacher or other staff from one primary school to another primary school within the jurisdiction of the same primary school council. But my whole endeavor to show your lordships that neither the board nor the council have an exclusive power of transfer. Their powers are circumscribed by the statutory rules. So statutory rules have to be obeyed by both the authorities. They cannot defy, they cannot apply the rules according to their whims. Now this has to be, my lord, kindly have a look at section 106 of the Act. But I just place here before you lost it. First, section 106, subsection 1. Lord, your lordships in every act will have this, find these provisions. Just but for the sake of the argument, I have to place it. The state government may, after previous publication, make rules for carrying out the purposes of the act. Lord, I put my submission purposes of the act, what? how the transfer to be carried out by the board and council, given under the provisions of the Act. This is the purpose of the rules. It's not offshoot simply. Then your losses kindly consider subsection 2. In particular,
No, that this argument which you are making, this is self-contradictory, Mr. Sannal, because this rule exactly says this rule will be.
no, I'm coming. My lord,
Please
my lord,
explain.
that I will explain. Division bench has explained it again. That I will take, but I want your losses fresh application of mine. That's why I'm placing it. I don't want
You
to
are relying upon any judgment.
Another judgment of division bench says this is applicable. So, my lord, let us proceed, your losses. Fresh as if arguing before losses.
Shorten it down, Mr.
My lord, it's a point of law, kindly, because everybody is urging that.
Yes.
So, losses deal with that. Because after all, this is the highest court.
Section
One has to, my lord, subsection 2.
of section
106.
Yes.
In particular, and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters.
Yeah, just one. কোনটা বললে?
Have to do it.
Hundred six.
Yes.
But first I have placed your losses subsection 1 and then 2. Subsection for carrying out the purpose of the Act, and subsection 2, in particular, and without prejudice to the generality of the foregoing power. Such rules may provide for all or any of the following matters. Your losses, just have a cursory looking. Your losses will not find any mentioning of section 19 nor mentioning of 60. So, my lord, K, any other matter which may be or is required to be prescribed. Required to be prescribed. The state legislature in its wisdom thought it fit that the rules has to be made. Procedures, guidelines, whatever your lordships use the expression, that has to be prescribed by rules. Otherwise, power has to be exercised illegally and capriciously. That's the object of the rules, not an offshoot. I'm dealing with my learned friend submissions. Now I take your, I will not repeat any submissions. I'll take your losses to the rule itself. Page 63, if I'm not wrong.
Page 63 of
the stay application. Now your losses will find this rule has been framed in exercise of the power of section 106, subsection 1 and subsection 2, clause K, as I placed before losses. At the very prelude, your losses will find it. Then your losses will find title of the Act, West Bengal Primary Rules, sorry, my lord. West Bengal Primary Education Transfer of Teachers, including Head Teachers Rule 2002. My learned friends, whole contention based on Sub-Rule 2. These rules shall apply to teachers, including the head teachers, for the purpose of transfer from one primary school to jurisdiction of other primary school. On the basis of this, my learned friends submission, this rule applies only to intra-council transfer, nothing else. Now your losses kindly, my learned friend has placed sub-rule 4, all okay, my lord. Kindly come to your lordships, my lord, the 8, inter-council transfer. In case of inter-council transfer, the council shall follow the principles and procedures of the board in accordance with the provisions conferred by subclause K of section 19. Now, this power under section 19 was vested with the board, not with the council. But why this was mentioned, your lordships? This rule was not properly framed according to, they thought it subsequently because of the amendment. Because ultimately this should be done by board. Board has to seek for materials from the council. Why? Suppose X wanting transfer from one council to another council, whether the school will suffer or not. Transfer is an incident service, not a matter of right. If because of transfer, If the school suffers, no transfer can be allowed. Pupil teacher issue will go. Apart from that, whether there is any disciplinary proceedings or not, that has to be seen. So, this rule was there, inter-council transfer will also applicable. Now, your lordship has to construe whether the sub-rule 2 of section 1 limit the express provisions in the subsequent provisions in the rule itself. Whether the applicability clause will be the guiding principle to exclude the express provision of the rule itself, as my learned friend wanting to do that. That's my advancement of argument will be to this extent. Now, this, therefore, the legislature was conscious of this. They amended these rules. Legislature conscious, the applicable in intra-council. What the amendment was made, your lordships? First, your lordships kindly consider page 70.
Page 70.
70. The old rule, unamended rule was substituted by these rules from 2021. Now kindly see how much this is expressive. Inter-council transfer. While considering inter-council transfer, in accordance with the provisions of clause K of subsection 19(1)(a) of the Act, the board shall, mandatory, it's not may, board shall mutatis mutandis follow the provisions of these rules.
So you could have amended 1, 2.
That's, otherwise, then nobody would come up before losses.
No. You could have amended
That's your losses function.
Why you are making so much of problem?
That's your
Amend 1, 2, finished, everything goes.
Particularly sub-rule. Particularly, the board shall mutatis mutandis follow the provisions of these rules, particularly sub-rule 3. It is so expressive. It applies to the inter-council transfer. The same rules provides.
It was said so because the legislatures were aware that in case of incurable diseases, you cannot be made to wait for 5 years.
That's I'm coming.
That is why, in its wisdom, knowing that we have made a mistake in 1, 2, we have not done so. How we will support Mr. Sannal to advance the argument? Now the state said that incorporate that.
I couldn't your losses follow.
This incorporation of provision of Rule 5, particularly Rule 5. What is 5? That is the ambit of the diseases suffered by an
Exactly.
So suppose a person was suffering from thalassemia, as in one case it has been done. He will die, Mr. Sannal.
Oh no, my lord, please. I just take your lordships.
We are on 2. You are trading into the details of the rules. Suppose, how can you exclude this, Mr. Sannal?
I'm coming.
If I said, maybe it would have been 10 years then.
May I come?
There has to be a reasonability in the...
My lord, please, it's a fair, my lord, I come to that.
The problem is the legislature has left it to the discretion of...
My lord, I come to that, your lordships. Thalassemia of whose?
We are not medical experts.
My lord, I'm not on that, I'm conscious of that. Now, my lord, the disease, incurable disease, your lordship says, thalassemia, incurable disease. Now, my lord, a person is posted in Nadia. He born in Nadia. What will happen the transfer, my lord?
Yeah, understand
what would be the transfer, my lord?
Your anxiety.
Well, it's not anxiety. Otherwise, the rule will fail. The purpose of the rule will fail. Suppose a person has not been transferred. He is a resident of Nadia. He got appointment Nadia. He is suffering from thalassemia. What will he do? He will ask for transfer. Why? Where?
Either leave the job or make an application.
Or, he can be treated from Nadia. It's not that. Everyone gets that treatment.
Mr. Sannal,
I can tell you, Lord.
What I am asking you, there are 2 different things. Which elaborate submission point of law you are making, we understand. But we are trying to appreciate that when the rules and the legislature consciously lays down certain diseases which requires to be taken into consideration, will this be compatible with 5?
I'm not on that. Dear lordships,
We will not answer that.
I
We
will
send it to
no,
you.
no, my lord. My learned friend says 2002 not applicable.
We will, sir, what you are saying, that we know how to.
Saying that this amendment, Rule 5.3 is applicable.
Well, how could it be? Rule is not applicable, is entirety not applicable.
Mr. Sannal, without finding out any reason to justify whether there should be 5 years limit in case of special ground or not, let us find out whether legislature has applicable this time limit in respect of transfer.
Therefore, my lord, may I accept it that your lordship accepting the applicability of the rules? Let me come, because this is I am dealing with the submission of learned friend. If your lordship say rule is applicable, then I will go to the next point.
Applicability, you are claiming that entire rule will apply.
Exactly.
He is saying that 5.3 will apply.
But how could it be? 5.3 applicable, then inter-council transfer?
No, Mr. Sannal, if we think it in this fashion, 5.3 says what? The nature of the diseases. Nothing less, nothing more.
No. More thing.
More things.
More thing. Kindly come to that. My lord, page 68, amended rules, C3.
5.3 এইখান থেকে আনতে হবে 5.3 page 68 amended.
Sub-rule 3 substitute the following sub-rules.
Yes.
An applicant may seek transfer on the following grounds. The same shall be considered by the council only against the vacancy available at the time of consideration, subject to the conditions made in sub-rule 3A in the following order of terms.
What is 3K? Oh.
Kindly come to. 3A will be also applicable when the board takes up the application. Pupil-teacher ratio checking is mandatory for application made under sub-rule 3.
Reject it.
No, Maladam, not that. Malad, kindly ask him to which provision, then one paragraph will be applicable to the rules, next of the not.
He has not challenged the virus. He is a submission which is being made, trying to point out the differences and the division bench judgment that 5 years time gap may not be considered.
Malad, that's your lordship's.
You are wondering that if we say so, we would be opening a floodgate. All the merit applications, you're justified. We understand your argument. But 7 accept your argument.
Malad,
How can
if your lordship say that 2002 rule applicable, but 5-year bar is not mandatory, it is directory. One thing. That's one thing. But applicability of the rule has to be protected.
We will not answer that issue.
Yes. Kindly answer that. Kindly answer that.
So much trouble.
No.
Mr. Sannal,
Now
if we treat this application as an application on special ground, we should not go either 5 years.
Oh, Malad, then again, then Malad, আমাকে অর্ডারটা দে বলে কাইন্ডলি হ্যাভ এ লুক এট
ধরে নেই যে
এটা তো কি এটাই দিয়ে দেবো আর কি করবে এটা তো খুব পয়সার অভাব
কোশ্চেনই আসছে না যদি ডিসচার্জ
কেন কিন্তু এটা আনরিপোর্টেড জায়গা
খুলে ফেল না তো ওতে খুব অভ্যস্ত
না আমি তোকে দিচ্ছি
acceptable.
আচ্ছা ও দেখালে কি
হ্যাঁ ওকে সুন্দর বাঁধিয়ে দিয়েছে তো তৈরি হোস না হ্যাঁ
Mr. Sannal, we will say that we will in view of the assertion of the disease which is being suffered by the person, as regards applicability of the rules, we are not going into it. We will simply say that Shubhadeep said that very serious disease and 5 years, these two are incompatible. So in certain cases it may be done. We are not touching the teacher-pupil ratio, your argument of merit selection. We are not going into that.
All right, your lordship, but this judgment I have to show to your lordship. The division bench, my lord, unless I will be, my lord, falling in performing my duties. Because your lordship, the same division bench, at least
you are very intelligent, you know what is to be done in what.
The same presiding judge passed this judgment.
Remember those days, Honorable Justice Ajit Sen Gupta's You used Just
No,
extend-
তখন WBACB was there.
ACB.
Myself, Shaptangshu Basu, and Justice Soumitra Pal.
So we have seen you since that day. So this much of leverage we can expect from.
No, I'm just, well, this is my bold submission was made. Kindly have a look at this. At the writ petition, as the behest of the writ petitioner, appellant board stood dismissed by the single bench after taking into account the report submitted by the council, and he is not a surplus teacher. At the first blast, the order appears as to be cryptic, but after inviting the council representing the respective parties, we do not find any infirmity or illegality in dismissing the writ petition for the reasons stated herein below. The petitioner was appointed as an assistant teacher in the primary school and prayed for a mutual transfer, which was eventually allowed. Subsequently, an application for transfer to a school situated within the territorial jurisdiction of another primary school council was taken out before the board, which was kept in suspended animation. Invited the writ petition to be filed before this court. Though the court should not substitute itself to exercise the powers of the administrative authorities, but it appears that the relegating the parties to an administrative authority would not yield any favorable decision, as the law applicable in this regard is unambiguous and stare at the face of the litigant that there is no infirmity in these rules. Section 19(1)(k) of the Act confers power upon the board to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school to a primary school within the jurisdiction of another primary council. Such powers appears to have been vested, and there is no corresponding provision appearing in the said section guiding the authorities to act in a particular manner. However, the West Bengal Primary School Transfer Rules 2000 rule was framed initially to apply in relation to a transfer of a primary school within the jurisdiction of the primary school council, because just my lord was conscious of the lord's own judgment earlier. But our attention is drawn to a subsequent amendment having been brought through a notification dated wherein the specific provision in relation to a procedure to be adopted for inter-council transfer was inserted in the following manner. Malan, I'm skipping over because I placed it. On the manifest reading of the subsequently inserted provision, though the board is an ultimate authority to take a decision for an inter-council transfer, but has to follow the procedure in this regard incorporated in Rule 5.3 of the aforesaid rules as a guiding tool. Since the said provision is to be applied mutatis mutandis, it is a principle enshrined therein, which is required to be followed by the authorities before it embarks a journey of deciding the said application for transfer filed by the primary school teacher. The original sub-rule 3.5 is a repository of provision relating to the preference given to an application necessitated by special circumstance. In other words, the said provision applies in relation to an order of preference given to applications filed under subsection 19(1)(k) of the Act and does not put any hindrance in adopting the procedure. However, by virtue of the aforesaid amended provision, sub-rule 3 of Rule 5 is to be followed, and by the same notification, sub-rule 3 was introduced, by which the conditions incorporated therein should be kept in mind, or in other words, followed under sub-rule 3 of Rule 5. It is beyond cavil of doubt that the application necessitated by any special circumstances are kept outside the purview thereof in certain circumstances, but does not rule out the applicability of a sufficient or excess teacher concept having been brought therein taken into account. According to the writ petitioner appellant, the transfer was sought to be ground of illness. Our attention is drawn to the application which does not indicate the specific disease, but in the writ petition it is stated that he is suffering from cervical spondylosis, which does not come within this peripheral of the disease under Rule 3A of the rule. It is not obligatory on the part of the board to transfer a teacher from one school situated in a primary school to another school under another primary if the circumstances doesn't warrant, more particularly being outside the ambit of the aforesaid provisions. The appeal is dismissed. So, the rule was said to be applicable. Now it is for your losses to decide. These are my humble submissions. তুই আমাকে করিস না, আমি সাকাম করতে পারি। Now your losses kindly decide. Now, my lord, may I make submissions for the honorable court? It's up to our lordship to accept. Kindly declare application of the rule and say, my lord, this 5 years is not mandatory. If you lost, because they want that also.
No, declared application of the
5 years.
in the, as has
Rule is applicable, but the limitation of 5 years is not always applicable. It has to be decided by the board in the facts of each case.
Yes.
That's your lordship. But applicability rule has to be protected. That's your lordship. That can otherwise the board will be tyrant, my lord. Kindly consider this. They will choose by face. This cannot be. Board has to apply the mind. Even my lord, somebody says this disease. But board has to consider that. Board doesn't have any machinery to consider. Board has to leave it to the Department of the Health. Here losses can get a certificate. I'm not much to say.
Yes, what is your stand? Are you agreeable to this? As regards, we will not return any finding on the argument made by Mr. Sannal as regards applicability of the rules in consonance with the provisions of the Act. We will not go into that, and in view of this judgment which has been cited. But so far as that bar, they will never consider. That we can say that in view of Shubhodip, that bar may not be held to be applicable in your case. We will direct the appropriate authority of the board to consider.
But kindly do not refer Subodhi. Consider our rules because our submission is different. Shubhodip, because I tell you,
Shubhodip is secondary.
Secondary.
All
The
right.
kindly do not. Because not the principle. Rule has both statutory rules. Our recruitment procedure is different.
My lord, don't take me amiss. There is a difficulty. In all such matters, board has taken this stand before the honorable single benches, referring to this matter that this issue is pending before the honorable division bench. Kindly do not decide, which will available in page number 12 of my judgment compilation. I have given that order also.
Very good.
The
Then
honorable court
what
has recorded,
problem you will face?
since this issue 2002 rule applicability is pending before the honorable division bench, we are not hearing this
No,
matter.
that may be argued, but that is exactly because your writ petition also does not take within its fold this applicable. This is an elaboration of the submission which you are making.
Because of the honorable single bench has observed the 2002 rules brought by the honorable single.
We will clarify.
Difficulties, other matters, since if it is not
come in a fit case.
So this is also, my lord, subject to correction is a fit case. Why I tell you, lordship, your lordship is referring to this judgment what my learned
No, then Mr. Laidy, you argue we deliver our judgment on the facts. If you insist for that, that is other.
Otherwise, this issue has to be settled, my lord, because many petitions, nearly 100, more than 100 petitions are waiting, looking at this judgment. That what would be done, because the order of the
if somebody looks at us, we cannot help somebody looking at us. We can explain our stand.
Because kindly take, my lord, why I am submitting. Kindly
Mr. Laidy, you will find it difficult in the sense this is not a challenge against the virus. You are causing the interpretation of the rules.
Yes.
You are asking us to interpret the rules. You have given a version. Mr. Sannal has given a version. Why should we go into that in this matter? If on the basis of the half of the problem is solved, that 5-year bar will not be applicable in the facts and circumstances of the case, try your luck before the single judge. And in an appropriate case, you come up.
But my request, your lordship, say rules is applicable. Otherwise, create difficulty.
If it is applicable, then my case goes. I have come that rule is not applicable.
Then your lordship deciding.
My learned senior friend is saying that rule is applicable. I am
No,
saying not
you want one part of the rule will be applicable, another part of the rule will be not applicable.
Your lordship has
Time limit will not be applicable. Otherwise, but the disease rule relating to disease will be applicable.
Why I tell you, lordship, my lord has seen several statutes where it says principles of civil code will be applicable.
It is not a fit case to go into the issue of the viability of the statutory provision. What is your prayer in the writ petition?
For consideration.
Otherwise, problem solved.
But the honorable single bench has.
Yes, sir. The present appeal has been.
Just 2 minutes I will take. Kindly allow 2. So far I have come, my lord. 2 minutes. 2 minutes. I will take 2 minutes. 2 minutes. I will not take more than that.
No, we have stopped Mr. Sannal. If you are arguing on that issue, we will go into the deep, go into the very plinth of the matter and applicability of the rules. We will decide. Choice is yours.
Choice is yours now.
Choice is now yours.
Since my lord board has already, I have the sufficient materials to come before with the lordship. This board has allowed division bench judgment is there, rule is there. So my lord, let it be.
Board has allowed what?
The below 5 is referring to 19(1)(k).
So we will refer to that.
2002 rule was never touched by the board.
Very good. That decision.
I have not argued on that. I will argue that.
Just not argued on
I
this.
will argue that.
So that point is to be decided.
No, he's insisting you answer that the rules are not applicable.
That's his insisting.
My understanding friend is saying that to hold that rule is applicable.
We are not saying that. Who told you that we are saying that?
Keeping the point.
We will only limit it to the issue of 5 years mandatory or not.
My lord, in next case, someone is affected by general transfer below 5 years. Now, this order will be cited that this point argument was made, but the honorable division bench has not decided.
But he will argue that provided we leave any sequence in our order, that it was
Now,
such a
one thing I
elaborate
tell you,
service.
Losses.
Keep this point open in this order.
Naturally, in the facts and circumstances, we cannot put conditions so much. You argue if you want, we cannot interpret our own order.
Absolutely.
Best finish.
Just only, my lord, in that case, the lordship has to observe that your lordship has not expressed any observation regarding applicability of 2002 rules. Then
So let us proceed on that applicability. Since my learned friend is also.
We will say it is not a fit case on the basis of the pleadings in the writ to go into the issue of determining the applicability of the rules. If you are insisting for that, we will make that observation. Finished.
আমি তো চাইছি সেটা আমার কি আছে
provision of these rules যখন হচ্ছে তখন enter এইখানটা particularly এটা আমরা particularized
করে খাচ্ছি না না করতে পারে
ডিসাইড হয়ে যাবে
ভাইরিস তো না অ্যাপ্লিকেবিলিটি আর এইখানে হচ্ছে পার্টিকুলার এটাকে আমরা পার্টিকুলারাইজ করছি আর এইখানে এই জিনিসটা থেকে আবার বেরিয়ে যাচ্ছে অ্যাপ্লিকেবিলিটির সঙ্গে একটা কন্ট্রাক্ট এই দেখুন এখানে অ্যাপ্লিকেবিলিটি হচ্ছে একটা
যেটা
That may be appointed with a disease of thalassemia, with a disease of cancer, then what will happen? 5 years bar malad necessary because of this to protect the merit. Transfer is another condition. Now, suppose he wants that my treatment will be only in the Calcutta. Otherwise not. I can understood that. That may be temporary transfer. There is no provision. So just because some disease, gynecological disease from one district to another district.
In the circumstances, it would be better not to give our reason, rather find out what legislator intended.
Exactly. Do that. So
Our
therefore,
my-
whenever your lawsuit,
My reason would be
whenever your whenever your lawsuit wants to do that, that means applicability of the rule is accepted. Otherwise, it cannot be. Whenever your lawsuit wants to do that, what was the intent of the legislature to put that condition with the specific disease in order, in following order, and the 5 years bar, then your lawsuit sees that the applicability of the rule is accepted. Once if there is no applicability of rule, then the entire thing goes.
না এটা তো জজ সাহেবটা ঠিক হয়ে গেল 5 বছরটা করে দিলেই তো মিটে গেল।
আমি জানি না
তো ও তো ট্রান্সফার
Yes, you want to say anything? My lord, yes, I need to rebut because what has been submitted.
But my lord, this is subject to I have not dealt with the other order of the board, other provisions I have in regard to applicability. If philosophy wants that, I can go on making submissions. I'm prepared to do that. If my learned friend insists on that.
Mr. Lahiri, you want us to declare that only 5 sub-rule 3 of rule 5 apply, not other portion. Whether Mr. Sannal said entire rule apply.
Respectful submission is this, my lord.
Because he want to avoid 5 years time limit. He want to avoid 5 year limit. So you want only 5(3) apply. Whether Mr. Sannal said no entire rule apply.
Your lordship has certainly gone through various statutes where your lordship will find a provision. The modalities of the civil procedure code would be followed in this case. There are specific sections.
That is another aspect of the fact. Any special act has not prescribed procedure, then he stated that procedure prescribed in CPC will apply.
Or evidence will apply.
That is another aspect of that.
I am taking that logic. Since it is not prescribed in the procedure, that is why since a specific procedure has been laid down, how it is to be done, modalities, medical verification is to be done, this, that, given. Only that procedural aspect is to be followed in case of.
You are seeking an answer to an issue which will render the entire transfer process to be negated. Try to appreciate.
Yes.
We are in the state. Suppose today, accepting what you are saying, we return a finding that this rule itself is not applicable. Then what happens? What happens as an aftermath? New rule has to be framed or nothing has to be done or Supreme Court has to be approached. Kindly appreciate the effectibility of the judgment.
Yes.
Today, you started your argument on the context that you treat my application as an application of special ground and this medical. So for that, if I am a patient suffering from diseases, how can I wait for 5 years? I may have further impact on me. So on that issue, we will express our opinion. As you have cited another judgment of another coordinate bench, not apart from standalone, it is on the basis of fixation, the incompatibility of this consideration, this 5 years wait and the severity of my illness. We find justification in that. But today, Mr. Lahiri, if you want us to decide the applicability of the rules as such, in that case, what happens? We have to return a finding. The entire transfer process will come to a standstill. It's an element of public service. How can we do so?
My response to this one, with deepest respect, I am submitting, my lord, possibly subject to correction, this will not have this catastrophic effect. Why? Because if your lordships hold that this rule is not applicable for inter-district, the similar manner, the way board has already so far has been issuing orders for transfer referring to 19(1)(k) will be continued. So far inter-district, 2002 rule will be followed. And so far inter-district, this procedure is already there, which is being referred by the board itself.
That is what you are challenging, no?
No, I will show the fallacy immediately.
I am just
of
showing
this.
your lordship that even without referring to 2002 rules, board is issuing transfer orders, referring to 19(1)(k) and the procedure. So there is no anomaly. In that way, it should go on. Because board itself does not refer to
Can we
2002.
prevent an authority from being sensible subsequently?
No, they are
That is to
correct.
come up for us for
I'm saying
challenge.
they are wrong. They are absolutely correct in
I'm
this.
saying I'm wrong.
They are correct.
Argument which will be advanced has to be dealt with.
Yes, I am
Anyway, we are keeping it as for orders. We
Hmm,
will pass the order.
Yes.
We will deal with your challenge in that manner.
I will revert to what my learned senior friend.
No further revert.
What
Yes,
can
we can deliver the order just now.
No, there are
We
certain
will
things
be
which are not
directing-
correct.
We will be directing the concerned competent authority of the board to consider your application irrespective of the fact of 5 years. This we will do, and we will mold the other arguments which you have made in an appropriate.
But my lord, certain things my learned senior friend has submitted with
If
deepest
the
respect.
applicability of the rules is not decided, what we are left to decide?
If your lordship is keeping
After
it
the
open.
learned advocates appearing for the respective parties have gone.
I've
Yes,
cited.
yes, just
That's-
stand and
yes.
sort.
And your lordship Subodip's judgment is
We understood.
That's not.
That judgment rather helps me, Sharoj. Sharoj's
Release the matter.
Sharoj's is in not on listed medical disease. Mine is listed medical disease. That is the major distinction.
In the daily supplementary list of this court on 10th February as fixed at 1 p.m.
10 February, 1 p.m.
Fixed at 1 p.m.
13th February.
13th.
Very well. Only one request in case your lordship holds, kindly keep that window open for this.
We will keep you open.
I'm always open before your lordship.
Chalo.
Grateful to your lordship. Much obliged to your lordship. Obliged to your lordship.
We take.